Hello and welcome to Unacademy. Today is lecture 2 of the BEAR Act. In the first session yesterday, we discussed provisions of the Indian Constitution right from the preamble to Article 72. In this session, let's continue from where we left yesterday. If you have not attended the session 1, please attend that after the session. I also promised you yesterday that I will cover the BEAR Act in 2 sessions. But guess what? I need one more session. So in total, in 3 sessions, I'm going to complete comprehensively the BEAR Act of the Constitution strictly for the prelims examination. Again, I'll tell you that these sessions are not going to be of any help for your mains examination, but for the prelims examination, these 3 sessions are going to be extremely helpful, fruitful and important. Today, let's look at the provisions of the BEAR Act from Article 73 onwards and let's see where we can reach. Should you need the PDF of this lecture, that shall be available on my Telegram channel. The link is provided in the video description. So let's get started, and before that, do not forget to press the like button and subscribe to our channel if you haven't yet. Let's get started and let's look at Article 74 of the Constitution. Yesterday, when we discussed Article 52, I told you it is one of the shortest articles of the Constitution. There shall be a President of India, which means our constitutional scheme cannot be envisaged to function even for a brief moment without somebody occupying the post of the President of India. Then Article 53 says all the executive powers are vested in the name of the President of India. But these 2 articles should not give a misleading sense that the president is all powerful, the most powerful entity, institution in the parliamentary system in India. Because we have to read Article 52 and 53 together with Article 74 of the Constitution. And listen to me carefully. It says there shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President. And this was the only provision in the original Constitution as it stood on 26 January 1950. The year was 1976, 42nd Constitutional Amendment Act. When Srimati Indira Gandhi was the Prime Minister, Constitution was amended to mention that this advice is binding on the President. There shall be Council of Ministers with the Prime Minister at the head to aid and advise the Prime Minister, to aid and advise the President. This was the original Constitution. Now in 42nd Amendment, what got added? Who shall act on that advice? That means making the advice of the Prime Minister and the Council of Ministers binding on the President. 2 years later, when Janata Party came to power, 44th Constitutional Amendment Act was passed. The year was 1978. Where again this Article 74 was amended. Now it says, whenever this advice is given to the President by the Prime Minister and the Council of Ministers, the President can ask for the reconsideration of that advice. But if the same advice is given again to the President has no other option but to act on that advice. Which means now the combined effect of both these amendments on Article 74 is that there shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall act on that advice. But the President may ask for reconsideration of that advice. But whatever advice is given, it shall be binding on the President to accept that advice. Which means, if the Prime Minister and Council of Ministers are advising the President to promulgate an ordinance, the President has to accept it. The President may ask the Prime Minister and Council of Ministers, could you please reconsider this advice? Is it necessary to promulgate an ordinance? But if the same advice is reiterated by the Prime Minister and the Council of Ministers, it shall be binding on the President to accept that advice. And Article 74 Clause 2 says, this advice which is given by Prime Minister and Council of Ministers to the President of India shall not be inquired into any court of law, which means on this particular matter there is no judicial review. That's Article 74. Article 75 talks about other provisions as to ministers. Constitution says the Prime Minister shall be appointed by the president. But is the constitution having any clarity as to who this prime minister has to be? No. This is where we say the president enjoys something called a situational discretion, which means if there is a political party which has won the election, the leader of that political party will have to be appointed as the prime minister by the president, which means the president does not have a discretion. But in some situations where there is a hung parliament, where there is no political party commanding majority on its own, this is where the president can use her discretion and appoint anyone as the prime minister. So we can say that the appointment of the prime minister is a discretion, or should we say a situational discretion of the president. But once the prime minister is appointed, only on the advice of the prime minister, other ministers shall be appointed by the president. Which means in appointing other ministers to the Council of Ministers, there is no discretion whatsoever available with the president. That's what Article 75 says. The prime minister shall be appointed by the president, and the other ministers shall, and this is binding on the president, shall be appointed by the president on the advice of the prime minister. But what is going to be the strength of this Council of Ministry? Because please understand carefully, Constitution does not talk about a cabinet minister or a minister of state or a minister of state with independent charge or a deputy minister. Constitution only says prime minister and the Council of Ministers. But what should be the strength of this Council of Ministry? Originally, there was no limit. But thanks to Mr. Vajpayee, when he was the Prime Minister, 91st Constitutional Amendment Act was passed. The year was 2003. Now there was a limit imposed. The strength of the Council of Ministers, including the Prime Minister, shall not exceed 15% of the Lok Sabha. Originally, in the original Constitution, there was no limit. Now a limit has been imposed via the amendment to the Constitution in the year 2003. Keep that in mind. This statement verbatim has been asked in the prelims examination. But something else. You also would know that a legislator can be disqualified on the grounds of defection under the 10th schedule of the Constitution. And who can disqualify a legislator on the grounds of defection? That power is with the Speaker of the Lok Sabha, the Speaker of the Legislative Assembly, the Chairperson of the Rajya Sabha, the Chairman of the Legislative Council. Can this defector be appointed as a minister? No. Who says this? Article 75 of the Constitution. But for how long? If I have defected and I have been disqualified as the member of the parliament, can I be appointed as a minister? No. But if I get re-elected to the parliament, then I can be appointed as the minister. But a defector cannot be appointed as a minister unless and until you get yourself re-elected. Where is it mentioned? Article 75 of the Constitution. And we say that all these ministers shall hold office during the pleasure of the president, which in reality means the pleasure of the prime minister. But if the question is asked in the examination, the ministers hold office during the pleasure of the president, which means there is no defined tenure for a minister. It's not that if you are appointed as a minister, you will continue to remain in office for 5 years. No, you will remain in office as long as you have the pleasure of the president, which means the pleasure of the prime minister. But collectively, Council of Ministers shall be responsible to, accountable to, not the Parliament, not the Rajya Sabha, but the lower house of Indian Parliament, which is Lok Sabha. And that is what we call parliamentary democracy. And this question has been asked at least 3 times in the last decade. Parliamentary democracy would mean that Council of Ministers are collectively responsible to, accountable to the lower house of Indian Parliament, which is Lok Sabha. And before a minister is appointed, before a minister assumes his or her office, oath of office and secrecy is administered. Who administers this oath of office and secrecy? This is administered by the president. But where is this oath of office and secrecy or affirmation of office and secrecy mentioned? It is mentioned in the third schedule of the Constitution. I am teaching BEAR Act right now. Is it possible for the Prime Minister to call me right now and tell me, gentlemen, come to Rashtrapati Bhavan, I will ask the President of India to swear you in as the minister, although I'm not a member of either Lok Sabha or Rajya Sabha? Is it possible? Yes. But within 6 months, I have to get myself elected to either Lok Sabha or Rajya Sabha. Or should I say, I have to get myself as a member of either Lok Sabha or Rajya Sabha, which means, for example, Dr. S. Jaishankar, when he was sworn in as the minister, cabinet minister in 2019, at that time, he was not the member of either house of the parliament. But then he had to get himself elected as the member of either Rajya Sabha or Lok Sabha. He got himself elected to the Rajya Sabha and he continued to remain in office. Important facts are very important for your prelims examination. Article 76 talks about another constitutional post called the Attorney General for India. Who is this Attorney General? Appointed by the President. But what should be the qualification of somebody in order to be appointed as the Attorney General for India? If you are qualified to be appointed as the Judge of the Supreme Court, you are qualified to be appointed as the Attorney General for India. Does that mean you should be a Supreme Court judge in order to be appointed as the Attorney General? No. Why? Because there is separation of powers between executive and the judiciary. If you are part of the executive, you cannot be part of the judiciary and vice versa. But somebody who is qualified to be appointed as the Judge of the Supreme Court becomes qualified to be appointed by the President as the Attorney General. And what is the qualification for someone in order to be appointed as the Judge of the Supreme Court? The qualification is you have to be the citizen of India. You should be a judge of one or more high courts for 5 years, or an advocate in one or more high courts for 10 years, or in the eyes of the President, you should be a distinguished jurist. Does that mean you have to satisfy all these criteria? No. You have to be the citizen of India and you have to be a high court judge or one or more high courts for 5 years. If not, then citizen of India and advocate of one or more high courts for 10 years. If not, citizen of India or in the eyes of the President, you should be a distinguished jurist. And this person is qualified to be appointed as the Attorney General for India as well. But what is the role? If today you and me have a dispute, I'll tell you, I will see you in court. And in the court, some advocate is going to be representing me. Similarly, an advocate is going to be representing you. But who will represent the union government in all the cases where union government is a party? That individual is the Attorney General for India. Attorney General also has some other responsibilities. For example, any legal advice which is sought by the President of India has to be given by the Attorney General, which means his role from time to time is assigned by the President. Listen to me carefully. If tomorrow it is asked in the prelims examination, the role of the Attorney General can be enlarged by Parliament, Prime Minister, Chief Justice, President, the answer is the President. And Constitution further says that this Attorney General has the right of audience in all the courts in this country. That means whether it's a high court of any state or the Supreme Court, Attorney General can just walk into and he has to be heard by the courts because you have the right of audience. And Constitution further says that this Attorney General, he does not enjoy security of tenure, which means the tenure of the Attorney General. Is it going to be a year or 3 years or 5 years or a decade? It's not mentioned in the Constitution. So you hold office during the pleasure of the President, which means during the pleasure of the Prime Minister. And what should be the remuneration paid to you? What should be the retainership paid to you? That shall be determined not by the Parliament, that shall be determined by the President of India. These facts are very important. Who decides the remuneration? Not Parliament, President. Who can enlarge your role? Not the Parliament, President. You hold office during the pleasure of the President. Is there any term mentioned in the Constitution? No. What sort of question has been asked from this topic previously? Let's look at the question which was asked in Prelims 2014. And the question is right at your screen. And tell me, what is the right answer? Attorney General for India can he take part in the proceedings of the Lok Sabha? Yes. Can he be a member of the committee of the Lok Sabha? Yes. Can he speak in the Lok Sabha? Yes. Can he vote in the Lok Sabha? No. Why? Because he is not a member. So what is the right answer? 1, 2, 3 is the right answer. But sir, I have a question. What's the question? You said this question has been asked as if it has been directly lifted from the Constitution of India. But by looking at Article 76, we will not be in a position to answer this question. For that, look at Article 88 of the Constitution. Rights of ministers and the Attorney General. Attorney General shall have the right to speak in the Parliament, to take part in the proceedings of the Parliament, to be part of any joint sitting as well, to be part of any committee as well. You can be even named a member of any committee, but you will not have the right to vote. Aren't these statements in verbatim picked as if they are directly lifted from the BEHR Act? That is why this BEHR Act becomes important, particularly, specifically for the prelims examination. Clear? Very good. Article 77. All the executive action of the Government of India shall be expressed to be taken in the name of the President. That means whatever decision is taken, although the decision is taken by the Prime Minister and the ministers, but the name is that of the President, in the name of the President of India, on behalf of the President of India. Article 77, this is Article 77, Clause 3. The President shall make rules for the more convenient transaction of business of the Government of India and allocation of ministers of the said business. What does that mean? Listen to me carefully. Does Constitution mention that we will have the Ministry of the Home Affairs, Ministry of Defense, Ministry of External Affairs, Ministry of Jal Shakti, Ministry of Agriculture, Ministry of Education? Is it mentioned in the Constitution? No. Then where is it mentioned? Rules, allocation of the business rules, 1961. Who makes these rules? President. Because all executive powers are vested in the name of the President. How will President exercise these powers? For that, rules will be made. And these rules, allocation of business rule, transaction of business rules, 1961. It is these rules which talk about various ministries. That's Article 77, Clause 3. Article 78, and I'll tell you a specific question directly was asked from this article in your prelims examination. The duty of the Prime Minister vis-a-vis the President, with respect to the President. It shall be the duty of the Prime Minister. What? You have to communicate to the President all the decisions that you are taking. And if you have been following newspapers closely, you might have read Prime Minister meets the President after he came back from a foreign visit, apprising the President of what he did on a foreign visit. When an important piece of legislation is passed by the Parliament, the bill is introduced by the government, then the Prime Minister meets the President. So it shall be the duty of the Prime Minister to communicate to the President all the decisions which are taken by the Council of Ministers. Not just that, to furnish information regarding the proposals of legislation. The President may ask the Prime Minister, What are the different bills that you are getting introduced in the parliament? I need that information. Similarly, if the president requires, a decision has been taken by a minister individually, but this decision was not taken by the Council of Ministry, was not taken by the cabinet, it was taken by an individual minister. The president may ask the prime minister that a decision was taken by an individual minister, but I want you to discuss it in the cabinet, discuss it in the Council of Ministry. It is the duty of the prime minister to do this, what is recommended by the president. That's Article 78 of the Constitution. For example, consider the following statements. The Council of Ministers in the centre shall be collectively responsible to Parliament. Correct or not? Collectively responsible to Lok Sabha, not the Parliament. Why? Because Parliament would include Rajya Sabha as well. The Union Ministers shall hold office during the pleasure of the President of India. Did we not discuss this? The ministers shall hold office during the pleasure of the President. Is it not mentioned in Article 75 of the Constitution? Yes, it is. The Prime Minister shall communicate to the President about the proposals for legislation. Where is it mentioned? Proposals for legislation. Word by word, line by line, in verbatim, asked in your prelims examination. Does it not make the BEAR Act very important for your examination, particularly prelims? I don't need to reiterate this further. Let's look at Article 79 of the Constitution. It talks about the Constitution of Parliament. And Article 79 says, the Parliament shall comprise of President, Rajya Sabha, Lok Sabha. Rajya Sabha, Lok Sabha, these are the Hindi names which were given later. Originally, we would say the Parliament consists of President, the Council of States, and the House of the People, which means this President is an integral part of both executive as well as the legislature. Somebody is asking why statement 1 is incorrect. Because Council of Ministers in the centre shall be collectively responsible to Parliament. No, to Lok Sabha. Because Parliament includes President, Rajya Sabha and Lok Sabha. But the parliamentary democracy says the Council of Ministers are collectively responsible to the Lok Sabha. Article 80 talks about the composition of the Council of States, which is the Rajya Sabha. And listen to me carefully, read this carefully. Council of States consists of 12 members which will be nominated by the President. And these individual MPs shall be nominated by the President from the category of art, literature, science and social service. Not more than 238 representatives of the Council of the States and of Union Territories. That means we will have 12 nominated members, not more than 238 who are to be elected from the states and Union Territories, which means the Union Territories which have a legislative assembly. Which means if you are asked what is the maximum strength of the Rajya Sabha, the maximum strength according to the Constitution is 250. But in the Rajya Sabha from Uttar Pradesh, 31 MPs will be present. Where is it mentioned? From Telangana, there will be 7 MPs in Rajya Sabha. From Andhra Pradesh, there will be 11 MPs in the Rajya Sabha. From Tamil Nadu, there will be 19 MPs in the Rajya Sabha. Where is it mentioned? It is mentioned in the 4th schedule of the Constitution. Now listen to me carefully. How are the MPs to Rajya Sabha elected? Now, if there is an MP to Rajya Sabha elected from the states, listen to me carefully. Constitution says these MPs shall be elected by the members of the Legislative Assembly of that state, by the elected members of the Legislative Assembly of that state, through a system of proportional representation system by means of single transferable vote. So, members to Rajya Sabha from the states are elected by whom? Who votes? elected MLAs of that state. So elected MLAs of Tamil Nadu will vote to elect 19 MPs to Rajya Sabha according to the proportional representation system by means of single transferable vote. But what if we need MPs elected from Union Territory of Delhi or Puducherry or Jammu and Kashmir? Because these are the 3 union territories where we have a legislative assembly. Are these MPs also elected on the basis of the proportional representation system by means of single transferable vote? Yes. But is this mentioned in the constitution? No. What constitution says? That representatives of the union territories in Rajya Sabha shall be chosen in such a manner as Parliament may by law prescribe. So Parliament will have the power to decide. And Parliament may also say, no, we will follow first past the post system, or we will follow any other method, not necessarily the proportional representation system by means of single transferable vote. But from the state's constitution itself prescribes proportional representation system by means of single transferable vote. This distinction is very important, can be asked in your examination. Now, Article 81 talks about the composition of the House of the People, the Lok Sabha. And again, listen to me carefully, take a look at the screen. Subject to provisions of Article 331. What is Article 331? Article 331, it gave one responsibility to the President. That dear President, if you are satisfied that Anglo-Indian community is not sufficiently represented in Lok Sabha, then what President could have done? President could have nominated maximum 2 MPs from Anglo-Indian community. But I told you yesterday that 104th Constitutional Amendment Act was passed in 2019, through which this Anglo-Indian reservation in Lok Sabha, it was done away with. But Article 81 says, subject to Article 331, Lok Sabha will have not more than 530 members who are chosen from the states and not more than 20 MPs who will be chosen from the union territories. So currently the maximum strength of the Lok Sabha becomes 550. Till 2019, it used to be 552 because we would include 2 nominated members from the Anglo-Indian community as well. That's important. But listen to me carefully. From one state, how many MPs will be there in the Lok Sabha? Constitution says that as much as possible, there should be a parity. Parity in the sense, for example, 1 million people should be represented by 1 MP, for example, which means if Sikkim has 2 million population, there should be 2 MPs from Sikkim in the Lok Sabha. If the population of UP is, let's say, 100 million, then 100 MPs should be there in Lok Sabha from UP, so that throughout the country, we will follow what is known as one person, one vote. As far as practicable, this should be followed. But then what about within the state? Each state shall be divided into territorial constituencies in such a manner that the ratio between population of each constituency and number of seats will remain the same practically throughout the state, which means if within the state of UP there is 100 million population, we have to divide 100 million population in such a manner that the ratio of population to seat remains the same. That means each constituency is to be divided in such a manner that for every constituency we have a 1 million population, 1 million votes, which means throughout the country as well as within the state, we need to follow this concept called one person, one vote. Right or wrong? Right. But now listen to me carefully. Constitution says under Article 82, because if population is the basis to get the number of seats in the Lok Sabha or the number of seats in the Legislative Assembly, this population figure we get to know after every census, after each census. Article 82 says after the completion of each census, there has to be a process called redrawal of the electoral boundaries, which is what we call delimitation. In simple terms, if the population increases, corresponding to that, the number of seats should also increase. Which means if the population of UP increases from 100 million to 200 million, that means now 200 seats should be allocated to Uttar Pradesh. And if the population of Tamil Nadu decreases from 50 million to 30 million, then ideally the number of MPs to Tamil Nadu should be reduced from 50 to 30, for example. And for that, after each census, there has to be a delimitation exercise. But now listen to me carefully. Who will conduct this delimitation exercise? Such authority that Parliament may by law declare. That means, is it necessary that this delimitation is conducted by the Delimitation Commission? No. Who else can carry on delimitation? Any other authority declared by Parliament. And Parliament has sometimes given this responsibility of carrying out delimitation to Election Commission. For example, delimitation in Jammu and Kashmir recently was conducted by Delimitation Commission. But delimitation in Assam recently was conducted by Election Commission of India. But sir, we have heard and we have read that there can't be delimitation till the census of, till 2026, there can't be delimitation now. And if the number of seats have to increase, that can only happen after the census of 2026, which means in 2031. Then why was delimitation carried out in Jammu and Kashmir? It was carried out in Jammu and Kashmir because Jammu and Kashmir is a union territory, not a state. It was carried out in Assam because the last time delimitation took place in 2002 in Assam and few northeastern states, delimitation was not carried out, it was delayed. So what was delayed was to be carried out now, and that was done by the Election Commission of India. But sir, you also said that the number of seats cannot increase. Because when delimitation was carried out after the census of 1951, then the census of 1961, then the census of 1971, the southern states protested, saying we would be at a disadvantage. Because the northern states, you are prioritizing them, incentivizing them because they have been unable to control the population. The southern states have been able to effectively put a check on the population. This is where Indira Gandhi was the Prime Minister, Constitution was amended, 42nd Constitutional Amendment Act was passed, and there was a freeze on delimitation till 2001. Then again, Constitution was amended to put a freeze on delimitation till 2026, which means after the census of 2031 only can we have delimitation. But the number of seats will not increase. But if the number of seats will not increase, then why was 2002 delimitation carried out? Why was the delimitation carried out in Assam? This delimitation was carried out, please listen to me carefully, for two reasons, and that is what we call internal delimitation. Sir, what is this internal delimitation? You would also know that in Lok Sabha, there are seats which are reserved for SCs and STs in proportion to their population. which means there were seats reserved for SCs and STs right from the commencement of the constitution, and this reservation was supposed to be for 10 years. But after every 10 years, we see that the constitution is amended and this political reservation for SCs and STs continues. But if it is based on the population, how will we get to know about the population after every census? Which means the number of seats reserved for SCs and STs increased from 1951, then in 1961, then in 1971. In 2002, delimitation was carried out to provide for an increase in the reservation of seats for SCs and STs. That means total number of seats, 543, will remain the same. But the number of seats reserved for SCs and STs will increase. That means that is why in 2002 delimitation was carried out to further provide for increase in the number of reserved seats for SCs and STs, because their population is increased without touching the overall number of the seats. Overall number will remain the same. And further, the reason number 2 why it was carried out is what we call internal delimitation, which means, for example, this is a state where in 1971, according to 1971 census, the population was 1 million, 1 million, 1 million, 1 million. That means total 4 million. And for this 4 million population, there were 4 seats. But then the population increased in 1981, in 1991, in 2001. And we realized that the population increased. Here it became 3 million, here it became 5 million, here it became 2 million, here it became 10 million. So let's say overall population increased to 20 million. Now overall seats will remain the same. It will remain 4. But we will redraw the boundaries in such a manner that in every constituency there are 5 million voters. This internal delimitation was carried out in 2002. And this internal delimitation also led to the increase in the number of seats reserved for SCs and STs without increasing the overall number of the seats. So what Article 82 of the Constitution does, it says after the completion of each census, the allocation of seats in the Lok Sabha and division of each state into constituencies will have to be readjusted. But who will decide that? Which authority will decide that? That Parliament will decide. And it can be given to either a delimitation commission or it can be given to Election Commission of India. Provided that such readjustment shall not affect the representation of the House of People until the dissolution of the existing House. Which means if the delimitation is done again, let's say in 2031, let's say in 2032, the next Lok Sabha will be in 2029. If this current Lok Sabha completes its term, then from 2029 to 2034. If the delimitation award is given in 2032, which means the number of seats in Lok Sabha increases from 543 to 643. Will that apply to the existing Lok Sabha? No. It will apply to the new Lok Sabha when it is constituted. That means unless and until this existing Lok Sabha is dissolved, then the new Lok Sabha will follow that new increased number of seats model. Where is it mentioned? Article 82 of the Constitution. But now listen to me carefully. From UP, we will have 80 seats. And this 80 is decided and has to be decided on the basis of the population figures. And this 80 is decided on the basis of which census population figures? That is 1971 census. But within UP, these 80 seats are divided in such a manner that the ratio between the population and the seat remains the same throughout that state. That population figure is on the basis of 2001 census. Sir, what are you trying to say? I am saying from UP we will not have more than 80 seats. because that is to be decided on the basis of the population, and that population figure is 1971. But within UP, can we divide these 80 seats in such a manner that at least in the entire UP state, for each population figure corresponding to that, we should have one seat, which means for every 5 million population, there should be one seat, or for every 1 million population, there should be one seat. That population figure will be taken off 2001 census. Where is it mentioned? It's mentioned in the Constitution itself and can be important for your exam. Article 83 further talks about what is the duration of the House of the Parliament. Because we say Rajya Sabha is the permanent House of Indian Parliament, not subject to dissolution. Is it mentioned in the Constitution? Yes. Where? Council of States shall not be subject to dissolution. It's a permanent House of Indian Parliament. But how do we ensure the permanent House of Indian Parliament, Rajya Sabha? Nearly 1/3 of the seats retire, 1/3 of the members retire every 2 years. Where is it mentioned? In Article 83 of the Constitution. House of People, on the other hand, it is not a permanent house. Lok Sabha is not a permanent house. It is subject to dissolution. But if it is not dissolved prematurely, then the ideal term of the Lok Sabha is for 5 years. It's mentioned in the Constitution. But if national emergency is imposed, during the period of national emergency, the term of the Lok Sabha can be increased by 1 year at a time. That means 5 years can become 6, 6 can become 7, 7 can become 8, 8 can become 9, 9 can become 10. Each time you have to increase it by 1 year at a time. But what if the national emergency is revoked today? This Lok Sabha will continue for a further period of 6 months. Which means if the term of the Lok Sabha is 5 years, but national emergency has been imposed, now the term has extended to 6 years. Then again extended to 7 years because emergency is still in place. But if emergency is revoked today, then this Lok Sabha will continue for a further period of 6 months, which means 7 years, 6 months, or 8 years, 6 months, 9 years, 6 months. Where is it mentioned? It's mentioned in Article 83 of the Constitution. Now comes the most important point. What is the qualification? There is a qualification prescribed by the Constitution. And then there is a qualification prescribed by the law passed by the Parliament. For example, the Representation of the People Act. You have to be absolutely sure as to what qualification is prescribed by the Constitution and what qualification is prescribed by the law passed by the legislature. Because Constitution says a person shall not be qualified to be chosen to fill a seat in the Parliament unless and until you are a citizen of India. And you have to subscribe to an oath. And that oath is mentioned in the 3rd schedule of the Constitution. And who will administer you oath? On behalf of the Election Commission of India, for example, your returning officer. For example, if you want to contest Lok Sabha elections, the returning officer for a Lok Sabha election is the collector. And if I want to contest election, first I have to be the citizen of India, and then I have to subscribe to an oath which is mentioned in the 3rd schedule, and I have to subscribe to this oath in presence of the official from the Election Commission of India who is the returning officer. This is mentioned in the Constitution. And then age is mentioned. If you want to become the member of the Lok Sabha, you should be 25 years of age, not less than 25 plus. And if you want to become the member of the Rajya Sabha, you should be not less than 30 years. This is mentioned in the Constitution. But further, Constitution says other qualifications, more qualifications, extra qualifications can be prescribed by Parliament by law. For example, the qualification is you have to be a registered voter in any parliamentary constituency of this country. Is that mentioned in the Constitution? No, that's mentioned in the Representation of the People Act. Constitution in terms of qualification only talks about you should be the citizen, you have to subscribe to an oath, you should follow this age. Not less than 25 for Lok Sabha, not less than 30 for the Rajya Sabha. That's it. Are you able to understand? Yes, no, maybe? Great. Now, sessions of the Parliament, then prorogation, then dissolution. The President of India shall from time to time summon each house of the Parliament. But look at the important detail here. To meet at such time and place as he thinks fit. Which means, is it necessary for Parliament to function and operate in Delhi, in the Parliament building? Or can a session of Parliament be also conducted in Tamil Nadu or in Karnataka? Yes. This is a very important statement for your exam. The President shall from time to time summon each house of the Indian Parliament to meet at such time and at such place as he thinks fit. But there is a requirement. In such a manner that the time gap between the first and the second session should not be more than 6 months. Which means, please listen to me carefully. Normally, we have a budget session, monsoon session, and winter session of the Parliament. Is that mentioned in the Constitution? No. Constitution does not talk about budget session, monsoon session, winter session. This is mentioned in the rules of the Parliament. Constitution only has a requirement that the President shall summon each house of the Parliament to meet at such time and at such place as he thinks fit, in such a manner that the time gap between the last day of the previous session and the first day of the next session should not be more than 6 months. Which means Parliament must meet at least 2 times in a given year. And then the President may from time to time prorogue the House as well. Prorogation means you are terminating the session. And the President can also dissolve Lok Sabha. President cannot dissolve Rajya Sabha because Rajya Sabha is the permanent house of Indian Parliament. Where is it mentioned? Article 85. But listen to me carefully. Right of President to address and send messages to houses. This is different from another President's address. And that is why it becomes important for you to understand and make a distinction. What is the difference? The President may address either House of Parliament. The President can address either only Lok Sabha or either only Rajya Sabha or both houses. And for that purpose require the attendance of members. The President may say, I am going to summon Lok Sabha and I want to address Lok Sabha. I want to summon Rajya Sabha and I want to address only Rajya Sabha. Or I want to summon both the houses. The President may send messages. For example, there is a Waqf bill which is pending in the Parliament. Related to that, the President may send a message to Parliament and the Parliament will have to consider that message. What is that message? What President wants us to do, wants us to discuss. Or it may not be related to any bill, it may be related to anything else. But that is something which is the right of the President. You have the right to summon either one house or both houses and require that the members of the Parliament attend your session. Or the President has the right to send messages to the Parliament and the Parliament has to consider that message. This is one President's address. There is something else. Special address by the President, that's Article 87. What is the special address? Once the new Lok Sabha is convened, this new Lok Sabha, once it is convened, then both Lok Sabha, the new Lok Sabha and the Rajya Sabha together are addressed by the President. That's what we call special address by the President. The other address is the right of the President. That at any point in time, the President may address either one house or both houses and require the attendance of those members. But then there is a special address. Special address is when the new Lok Sabha is convened, then the first session of the new Lok Sabha together with the Rajya Sabha, they are assembled together and the President addresses them. And then every year, the first session of a year, the first day of the first session of the year is addressed by the President. That is not covered by Article 86, that's covered by Article 87. At the commencement of the first session after each general election to the House of the People, and at the commencement of the first session of each year, the President shall address both houses of the Parliament. The previous one is either one house or both. Here it is both houses assembled together. And then the President will also inform the Parliament, why am I summoning both houses of the Indian Parliament? And the text of this speech is prepared by the Cabinet. That's Article 87. Something else. Vacation and resignation of and the removal from the office of the Deputy Chairman. Now listen to me carefully. A member holding office as Deputy Chairman, which means is the Chairman of the Rajya Sabha member of the Rajya Sabha? No. But is the Deputy Chairperson of the Rajya Sabha member of the Rajya Sabha? Yes. Because a member alone can hold the office of the Deputy Chairman. And this Deputy Chairman, he shall vacate the office of the Deputy Chairman. When? When you cease to be a member. Which means once your term of the Rajya Sabha is over. What is the term of the Rajya Sabha MP, by the way? 6 years. But is that mentioned in the Constitution? No. That is mentioned in the law passed by the Parliament. It's not mentioned in the Constitution. So if your term is 6 years and you are a Deputy Chairman of the Rajya Sabha, now your term is over, you shall cease to be the Deputy Chairman of the Rajya Sabha. Because now you are no longer the member. Because only a member can be the Deputy Chairman. Or you may resign. How will you resign? You will submit your resignation to the Vice President, to the Chairman of the Rajya Sabha. Or you may be removed. But on what grounds will you be removed? Those grounds are not mentioned in the Constitution. So the grounds of removal for the Vice President, the grounds of removal for the Deputy Chairman of the Rajya Sabha, they are not mentioned. But what is mentioned is by what type of majority can you be removed? And you can be removed by the effective majority. But if I want to remove you as the Deputy Chairman of the Rajya Sabha, first I have to give 14-day notice, just like we discussed in the office of the Vice President. Same 14-day notice applies to the Deputy Chairman as well. These facts are very important. Power of the Deputy Chairman or other person to perform the role of the Chairman. Now listen to me carefully. Who presides over Rajya Sabha? Chairperson of the Rajya Sabha? And who is the chairperson of the Rajya Sabha? The Vice President of India. But if the chairperson of the Rajya Sabha is absent, who will preside over Rajya Sabha? Deputy Chairperson of the Rajya Sabha. But if the post of the Deputy Chairman of the Rajya Sabha also is absent, I am talking about absent, then who will preside over Rajya Sabha? This will be decided by rules. Because I told you yesterday Rajya Sabha can have its own rules. Lok Sabha can have its own rules. But what are the rules that shall be made applicable to a joint sitting? That President will determine after consulting the Speaker of the Lok Sabha and the Chairperson of the Rajya Sabha. So if the Vice President of India is absent, Deputy Chairman of the Rajya Sabha will preside over Rajya Sabha. But if the Deputy Chairperson is also absent, then who will preside over Rajya Sabha? For that, rules have to be made by the Rajya Sabha. And these rules say it can be anyone from the panel of 6 vice chairmen. But if any of this 6-member panel is also not present, then anyone determined by the Rajya Sabha will preside over. It's about absent. Rajya Sabha session is today. There is no vice president because vice president is absent. Office is not vacant. Vacancy is because of death. Vacancy is because of resignation. Vacancy is because of removal. Vice president is absent. Maybe he set up an alarm which did not ring and he is asleep. Or he is busy. He is traveling to North Pole, South Pole, or in a different part of the world. So he is absent. In his absence, who will preside over Rajya Sabha? Deputy Chairperson. He also is unable to wake up early in the morning to attend the session. That's what we say. If you snooze, you lose. He set up the alarm to wake up early in the morning. He pressed the snooze button. He is gone. In that case, who will preside over Rajya Sabha? Rules will determine. And according to these rules, there is a panel of 6 vice chairperson. But if these members are also absent, then anyone decided by the council at that time, Rajya Sabha at that time will preside over Rajya Sabha. Council will determine. Rajya Sabha will determine. But the situation changes when we talk about vacancy. If the office of vice president is vacant, vice president is dead, vice president has been removed, vice president has resigned, in that case, who will preside over Rajya Sabha? Deputy chairperson. But what if deputy chairperson is absent? Who will preside over Rajya Sabha? Not this panel. Rules will not determine. President will appoint somebody from Rajya Sabha to preside over Rajya Sabha. Because the office of the vice president is vacant. Because it was the vice president who set up this panel. And now vice president's panel is also gone. It is the president who will determine who will preside over Rajya Sabha. And there is a similar thing for the speaker as well. Under Article 95 for the Lok Sabha as well. In Lok Sabha, who presides over Lok Sabha? Speaker. If speaker is absent, deputy speaker. If there is no deputy speaker, because 17th Lok Sabha, the last Lok Sabha was the first one where we did not have a deputy speaker. And in absence of deputy speaker, rules of the Lok Sabha will determine who will preside over Lok Sabha. And these rules say we should have a 10-member panel of chairpersons. But if anyone from that panel is also not present, then Lok Sabha will determine who will preside over Lok Sabha now, because the speaker is absent. But if there is a vacancy in the office of the speaker, who will preside over Lok Sabha? Deputy speaker, because deputy speaker is a constitutional post. But deputy speaker is absent, or deputy speaker's post is also vacant, then president will determine who will preside over Lok Sabha. At that time, rules will not determine. The president will determine who will preside over Lok Sabha. So there is a difference between vacancy and when the chairperson or the speaker is absent. And you have to be absolutely clear what is the situation when either of the two conditions arise. Got it? If you're able to understand this, let me know. Perfect. Now, those who haven't yet liked the session, do that now and let's continue. I will wait for 5 seconds. Article 93, it says the House of the People shall, making it mandatory, shall elect two of its members. One is the Speaker and the other is the Deputy Speaker. Which means there has to be a Deputy Speaker. There has to be a Speaker. So why didn't we have a Deputy Speaker in the last Lok Sabha, and why do we not have a Deputy Speaker now? I don't have an answer. That's something that you should ask the Prime Minister or the Speaker. But who sets the date of election of the Speaker? President. Who sets the date of the election of Deputy Speaker? Speaker. The House of the People, which means Lok Sabha, shall, as soon as may be, choose two of the members of Lok Sabha, respectively. One is the Speaker, the other is the Deputy Speaker. And once the office of the Speaker or Deputy Speaker becomes vacant, then you have to fill that vacancy by choosing another person as the Speaker or the Deputy Speaker. But there must be the Speaker and the Deputy Speaker. By looking at Article 93, do you find it mentioned anywhere that the Speaker should always be from the ruling party or the ruling coalition, and the Deputy Speaker should be from the opposition political party? No. It's not mentioned. Anyone who is the member of the Lok Sabha can be chosen as the Speaker, regardless of whether you are from the ruling party or the opposition. This was the question asked in one of the prelims examination. According to the Constitution, while the Speaker is from the ruling party, the Deputy Speaker is from the opposition. That's not according to the Constitution, because Constitution says you have to be a member of the Lok Sabha. Now, whether you are from ruling party or opposition doesn't matter. You have to be the member, and then you have to be elected, chosen. That's Article 93. But now let's look at the vacation. If you are holding the office of the Speaker or the Deputy Speaker of the Lok Sabha, how can there arise a vacancy in this office? If Mr. Om Birla is the Speaker of the Lok Sabha and tomorrow Mr. Om Birla resigns, or Mr. Om Birla dies, or Mr. Om Birla is disqualified, that will cause vacancy in the office of the Speaker. Or vice, this Speaker's post, Mr. Om Birla, is to be removed. At any time you may resign. At any time you may resign by submitting your resignation to the Deputy Speaker. Deputy Speaker can submit his resignation to the Speaker. Or you may be removed. And you are removed also if the resolution is passed by the effective majority. Sir, how do we know whether it is effective majority or simple majority? Because whenever Constitution mentions, this should be passed by the majority of all the then members. This then members means effective strength. And more than half of the effective strength becomes effective majority. But again, if you have to remove the Speaker or the Deputy Speaker, you have to give them 14-day notice. I don't know whether I was telling this to you or I was telling this to my students in the class in the morning. If you understand Union Executive, you don't have to read State Executive separately, barring few exceptions. If you understand Union Legislature, there is no need for you to read State Legislature separately, because the same parliamentary system that we follow at the center, we follow in the states as well. That means same position is for the Speaker of the Legislative Assembly, Deputy Speaker of the Legislative Assembly. provided, and this is a very important point. What's the point here? If the House of the People is dissolved, and when the House of the People is dissolved, when the Lok Sabha is dissolved, Speaker does not resign. Is it convention or is it constitution or constitutional provision? It's a constitutional provision because the Speaker does not resign. Even if the Lok Sabha is dissolved, Mr. Om Birla will not resign. Mr. Om Birla will resign only when the new Lok Sabha is convened. And before the first meeting of the new Lok Sabha, that morning, the previous Speaker will resign to ensure continuity in the office of the Speaker. That is very important point. It's not a convention, it's a constitutional provision. Provided that whenever the House of the People is dissolved, the Speaker shall not vacate his office until immediately before the first meeting of the House of the People after the dissolution, which means the new Lok Sabha. Article 100, voting in the houses. All questions at any sitting of either house or joint sitting of the two houses shall be determined by the majority of votes of all the members present and voting, which means everything, every question, every ordinary bill has to be passed, decided in the Parliament by simple majority. But while calculating simple majority, do we include Speaker or the Chairman? No, we exclude them. Other than the Speaker or the person acting as the Chairman or Speaker, we exclude them in calculating the simple majority. Now, for example, there is a bill which has to be decided by the Lok Sabha or by the Rajya Sabha. On that, we require simple majority. The Speaker does not vote in the first instance. That means if on this bill, majority is in favor, minority is against, the bill is passed, Speaker will have no role. But if on this bill there is a tie, let's say 200 MPs are in favor, 200 are against, my one vote will determine whether this bill will be passed or rejected. I will have a casting vote. That means normally the presiding officer, you do not vote in the first instance. You only vote in case there is equality of votes, in case there is a tie, and that is what we call casting vote. But listen to me carefully. How many members should be present in the Parliament so that the proceedings, the business of the Parliament can take place? Just 1 second. How many members should be present? And that's what we call quorum. Constitution says that the quorum would be 1/10 of the total number of the members of that house. Which means in Lok Sabha it has to be 55. If 55 MPs are present, the business of the Parliament can take place. If less than that are present, this presiding officer will say, for the lack of quorum, we are adjourning the house. But can this 1/10 number become half or 2/3 or 3/4? Yes. Which means can the quorum tomorrow be 1/2 of the members or 1/4 of the members? Yes. Who will decide that? That will be decided by the Parliament. Till the time Parliament decides what should be the quorum will be the 1/10 of the total number of members of that. Now, vacation of seats. This is also important considering the fact that we have one MP from Punjab who is currently in jail in Assam, Mr. Amritpal Singh. There is another MP who was also in jail but was recently given bail just to attend the Parliament. Custodial bail, as we call it, Engineer Rashid from Jammu and Kashmir. That is why there was a detailed article in the Indian Express as well, why Amritpal Singh should not worry about Article 101. What is that? No person can be the member of both houses of the parliament. So you can't be member of both Rajya Sabha as well as Lok Sabha. That's not possible. Second, can you be the member of the parliament and member of the state legislature as well? No, that's also not possible. What if you are chosen both as parliament member as well as legislative assembly member? Then your seat in parliament will become vacant. Unless and until you decide, no, I will give up my seat in the state legislature. So I am resigning from state legislature. I want to continue as the member of the parliament. So can you be a member of Lok Sabha and Rajya Sabha at the same time? No. Can you be a member of the parliament and member of the state legislature at the same time? No. Now, if the same person is elected both to parliament as well as state legislature, then your seat in the parliament will become vacant. Unless and until you have decided, no, I want to resign from the state legislature. And if for a period of 60 days, you are continuously absent from the parliament, then it shall be deemed the House may declare that your seat is vacant, which means now a fresh election, by-election has to be conducted in your constituency. But how do we calculate these 60 days? 60 days not of the calendar year, 60 days of the parliamentary calendar. Which means if the House is adjourned right now, we don't include that period in deciding, calculating the 60 days. But if the House has been in session, on all those days on which the House was in session, we will include those days. And if you have been continuously absent for 60 days, the House may declare your seat vacant. House, that means the Lok Sabha has to vote by simple majority to decide that Amritpal Singh, your seat is vacant. But normally what happens is that the member who is absent, continuously absent, he writes to the parliamentary committee on attendance and tells them that I will remain absent because I am currently in jail. And normally they agree, okay, you will remain in jail, but you will not, your seat will not be vacated. But if the House declares that no, your seat should be vacated, then if for 60 continuous days you are absent without the approval of the House, without the approval of the parliament, then the House may declare your seat to be vacant. And you may also resign. And how will you resign? You will submit your resignation to the Speaker. But the Speaker will have to conduct an inquiry to determine whether this resignation is voluntary or whether you have been forced to or coerced into resigning. If your resignation is voluntary, the Speaker will accept your resignation. If the Speaker, after an inquiry, believes that you have been coerced into resigning, this resignation was not voluntary, the Speaker may not accept your resignation. Article 105. Constitution says there shall be freedom of speech in the Parliament, which means no matter what you say inside the Parliament or any vote that you give inside the Parliament, for that you will not be held accountable in any court of law. And for that there was a historic case related to the JMM bribery. PV Narasimha Rao versus CBI, where Supreme Court has said that if you are taking bribe to vote in one way or the other inside Parliament, even bribery is allowed. But luckily, in Sita Soren case last year, Supreme Court overruled that JMM bribery case, saying no, bribery is not part of your privilege. Which basically means that there is an absolute freedom of speech in the Parliament. Normally, you and me, we have a freedom of speech and expression guaranteed under Article 19(1)(a). but there are reasonable restrictions on our free speech. We have discussed yesterday that there are 8 reasonable restrictions on our free speech, 8 grounds: sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, morality or decency, contempt of court, defamation, incitement to an offense. But these restrictions do not apply to a member of the parliament while speaking inside the parliament. Inside parliament, you have an absolute freedom of speech. No matter what you say, no matter how you vote, you will not be held accountable in any court of law. Sir, I have a question. What? Sir, why is it that whenever a member of the opposition is speaking, the speaker says nothing will go on record, your language was obscene, we will remove your speech or your statements? House can have its own rules. And these rules say that your content should not be defamatory, or you should not refer to someone else who is not a member of the parliament inside your speech. So action is taken against you by the House. You may be expelled by the House. You may be suspended by the House. Privilege initiatives or breach of privilege motions can be taken up against you by the House, but not by any court of law. Protection is you will not be held accountable in any court of law for whatever you have said in the parliament or any vote that you have given in the parliament. But each house has its own rules, and according to those rules, action can be taken against you, but not by any court of law. For these privileges, Constitution originally said that there should be a law, so that this law can codify all these parliamentary privileges. And Constitution further said, till the time such a law is passed to codify all these parliamentary privileges, whatever privileges were available to British MPs and British Parliament will apply to Indian Parliament as well, will apply to Indian MPs as well. For example, you might have read that while the session of the Parliament is going on, no MP can be arrested during the session, 40 days before the session, 40 days after the session. Is that something mentioned in any law? No, that's a British privilege that is applicable to India as well. If you are to be arrested in a civil case, if you're arrested, to be arrested in a civil case or in a contempt of court case, you can be arrested even when the session of the parliament is going on. But you have to take the permission of the speaker. Long story short, Article 105 and similar provision is there for the state legislature as well, for the legislative assembly MLAs and MLCs as well, that Parliament should enact a law to define what are the powers, privileges, immunities that are available to Parliament as an institution and parliamentarians as individuals. Until the time such a law is passed, all the British parliamentary privileges shall continue in India. But the year was 1978, 44th Constitutional Amendment Act. What this amendment said? All the privileges that were in force prior to this amendment, those privileges will continue after the amendment as well. Which means, what were the privileges in force prior to the amendment? British privileges. Those privileges will continue after the amendment as well. That means, is there any change? No change. Whatever privileges were there, those privileges are now as well, because Parliament has not enacted any law. Then what has changed? What was the need for this amendment? We just dropped the reference to British Parliament, because when the minister introduced this bill in the Parliament, he said, why should our Indian constitution, a sovereign constitution, a sovereign country, refer in its constitution to a British practice? That's why we want to drop this reference of Britain, which means the same privileges will continue to Indian MPs as well, to Indian Parliament as well, except that we have dropped this reference to British. We don't call them British privileges. We only say whatever privileges were in place prior to this amendment, those will remain in force even after the amendment as well. Article 107, it says subject to the provisions of Article 109. 109 deals with money bills. And 117 deals with financial bills. Both money bills and financial bills, they can be introduced only in Lok Sabha. Apart from these two, money bills and financial bills, a bill may originate in either of the House of the Parliament, which means an ordinary bill can be introduced in either Lok Sabha or Rajya Sabha. And then this bill shall be deemed to have been passed only if it has been agreed upon by both the houses. That means both the houses have decided to pass this bill by the majority. A bill which is pending in Parliament shall not lapse by reason of the prorogation of the houses. Budget session is there, budget session has been prorogued, that means terminated. Does that mean the bill, for example, the Waqf bill, which is pending in the Parliament, will lapse if the House is prorogued? No. It will be discussed then in the winter session, or in the budget session next, or in the monsoon session next. A bill pending in the Council of States, which has not been passed by the House of the People, shall not lapse upon the dissolution of the House of the People. A bill which is pending in the Council of States, which means Rajya Sabha, that means this bill is pending in Rajya Sabha, which has not been passed by the House of People, which means it never went to Lok Sabha, which means this bill originated as well as is pending in Rajya Sabha. Such a bill will not lapse upon the dissolution of Lok Sabha. A bill which is pending in the House of the People or which has been passed by the House of People is pending in the Council of States shall lapse upon the dissolution of the Lok Sabha, which means there is a bill which is pending in the Rajya Sabha, but this bill has been passed by Lok Sabha already, which means the origin of this bill is Lok Sabha. Any bill whose origin is Lok Sabha, whether it is pending in Lok Sabha or Rajya Sabha, doesn't matter, the bill lapses upon the dissolution of Lok Sabha. For that, let's take a look at the question which was asked in Prelims 2024. And you tell me what is the right answer. Mention it in the question. Mention it in the comment section. With reference to Indian Parliament, consider the following statements. A bill pending in Lok Sabha lapses on its dissolution. Correct. A bill passed by Lok Sabha and pending in the Rajya Sabha lapses upon the dissolution of the Lok Sabha. Correct. Because what type of bill does not lapse? A bill which is originating in the Rajya Sabha, pending in the Rajya Sabha. A bill in regard to which the President of India has notified her intention to summon joint sitting lapses on the dissolution of the Lok Sabha. No. There are three kinds of bills which do not lapse upon the dissolution of Lok Sabha. A bill which is originating in the Rajya Sabha and is pending in the Rajya Sabha, it does not lapse. A bill which is waiting for the President's assent, which has been passed by both houses, is waiting for the President's assent. That bill also does not lapse. And a bill on which the President has notified joint sitting, that bill also does not lapse. Now you tell me, if there is a deadlock on a bill, deadlock is one house passes a bill, other house does not agree. That means finally we have a disagreement over this bill. How do we resolve this deadlock? The President notifies a joint sitting. What if I ask you, any bill on which there is a deadlock does not lapse upon the dissolution of Lok Sabha? Would that statement be correct? Any bill on which there is a deadlock does not lapse upon the dissolution of Lok Sabha. Will that statement be correct? No. The only thing which will save this bill is if on this bill President has notified a joint sitting. That means all those bills on which there is a deadlock, if the origin is the Lok Sabha, or even if the origin is not Lok Sabha, finally there is a disagreement, there is a deadlock on this bill, it will lapse upon the dissolution of Lok Sabha. The only thing which can save such a bill is if the President has notified a joint sitting. Now, one more interesting thing. On a particular bill on which there was a deadlock, President notified a joint sitting. Once President notified a joint sitting, after that Lok Sabha got dissolved. What will happen to this bill? This bill will survive, regardless of whether Lok Sabha was dissolved after that or not. Because when the President notified this joint sitting, there was already Lok Sabha. After notifying joint sitting, if the Lok Sabha got dissolved, doesn't matter, the bill still survives. These are important things. Can be relevant, hugely relevant for your exam. What is also relevant is Article 108. What is Article 108? Joint sitting. What is this joint sitting? Let's say this is Lok Sabha and this is Rajya Sabha. Listen to me carefully. Lok Sabha passes a bill, Rajya Sabha passes a bill. What will happen to this bill? This bill will go to the President for assent. No dispute whatsoever. Lok Sabha passes a bill, Rajya Sabha can reject a bill. Lok Sabha passes a bill, Rajya Sabha may not act on this bill. Lok Sabha passes a bill, Rajya Sabha amends this bill. These are the options available with the other house. Or it can be reverse. Rajya Sabha passes a bill, Lok Sabha rejects a bill. Rajya Sabha passes a bill, Lok Sabha amends a bill. Rajya Sabha passes a bill, Lok Sabha does not act on this bill. Now what will happen? The moment other house rejects a bill, there is a deadlock. That means finally both houses have disagreed. Other house may not act on this bill. For how long will we wait? We'll wait for 6 months. Once 6-month period is over, we say there is a deadlock. The other house may amend this bill. If you amend this bill will go back to the other house. If Lok Sabha accept these amendments, if the other house accepts these amendments, no problem whatsoever. We will accept it. No deadlock. But if the other house rejects these amendments, then there is a deadlock. And to resolve this deadlock, there can be a joint sitting notified by the President. And the President notifies this joint sitting on the advice of the Prime Minister and the Council of Ministers. And in this joint sitting now, this clause will not apply to money bill. Because money bill is, on money bill, the Rajya Sabha, even if it disagrees, it has inferior role. On money bill, there can't be a joint sitting mentioned in the Constitution. But because it is a joint sitting, which means numerically Lok Sabha is dominant over Rajya Sabha, which means it is the will of Lok Sabha which prevails in a joint sitting. How many times have we conducted joint sitting? 3 times. The first one was on the dowry prohibition bill. The second was on the banking regulation bill. The third one and the last one was in 2002, quota. After that, we haven't conducted a joint sitting. Okay. Article 109 talks about special procedure with respect to a money bill. A money bill shall not be introduced in the Council of States. What is mentioned here? Money bill can be introduced only in Lok Sabha. That too on the prior recommendation of the President of India, with the prior approval of the President of India. Interesting question is, can this money bill also be a private member's bill? Or should it always be a government bill? What is a private member's bill? A bill which is introduced by a non-minister is a private member's bill. A bill introduced by a minister becomes a government bill. So this money bill, should it always be a private member's bill or always be a government bill or can only be a government bill? No, that's not mentioned in the Constitution. The only requirement is that a money bill can be introduced only in Lok Sabha, that too with the prior approval of the President. If the President gives prior approval to a private member to introduce a money bill, problem solved. It's another matter, why would President give prior approval to a private member to introduce a money bill, although it has been done previously once. So a money bill can be introduced in Lok Sabha with the prior approval of the President of India, and then in Lok Sabha it should be passed by simple majority. Once this money bill is transmitted to Rajya Sabha, it is attached with a certificate by the Speaker. And Constitution says that certification by the Speaker is final and binding, which means a certificate is issued along with this bill to the Rajya Sabha, informing the Rajya Sabha that this bill which is coming your way is a money bill and you have a limited inferior role. Because what Rajya Sabha can do, Rajya Sabha may pass this money bill. What Rajya Sabha cannot do, Rajya Sabha cannot reject a money bill. What Rajya Sabha cannot do, Rajya Sabha cannot amend a money bill. What Rajya Sabha can do, Rajya Sabha can make recommendations. If these recommendations are acceptable to Lok Sabha, the bill is passed. If they are not acceptable to Lok Sabha, even then the bill is passed, without considering these recommendations of the Rajya Sabha, showing Rajya Sabha has an inferior role. And what if Rajya Sabha does not act on this bill? If you don't act on this bill and the 14 days are over, it shall be deemed that the Rajya Sabha has also passed this money bill, which means on a money bill, Rajya Sabha has an inferior role. A money bill shall not be introduced in the Rajya Sabha. After a money bill has been passed by Lok Sabha, it shall be sent to Rajya Sabha for its recommendations. And these recommendations have to be sent within 14 days. And once these recommendations are sent to Lok Sabha, either Lok Sabha may accept or reject these recommendations. If the Lok Sabha accepts any of these recommendations, then the bill is passed. If not, even then the bill is passed, without any of the amendments or recommendations suggested by the Council of States, by the Rajya Sabha. And if it is not acted upon by the Rajya Sabha for a period of 14 days, it shall be deemed that both houses of the Parliament have passed this money bill. Now let's look at Article 111, Assent to Bills. This is where it becomes very important and interesting. When a bill has been passed by both houses of the Indian Parliament, it is sent to the President for assent. Because a bill has to be passed by the Parliament, and Parliament includes President, Lok Sabha and the Rajya Sabha, which means all the three entities, all the three institutions will have to pass this bill. Once both houses of the Parliament pass this bill is sent to the President for assent. What are the options available with the president? President may either give her assent, and when the president gives her assent, there is no doubt, confusion whatsoever, no dispute whatsoever. The president may withhold her assent. That means the president will publicly declare, I am not going to sign this bill. These are the two options. But Constitution says when the president invokes option 2, then what president has to do? President has to send this bill back to the parliament for reconsideration. Except a money bill. Money bill cannot be sent back to the parliament for reconsideration by the president. Where is it mentioned? It is mentioned in Article 111. Which means this option is not a third option for the president. Listen to me carefully. This is where most of the students get it wrong. This is not the third option available with the president. This is the continuation of option number 2. When a bill is sent to the president for assent, either the president may give her assent or the president may withhold her assent. But when the president withholds her assent, that does not mean this bill is dead. That means this bill has to be immediately sent back to the parliament for reconsideration, except if it's a money bill. Because money bill cannot be sent back by the president for reconsideration. Which means on a money bill, the president may either give her assent or withhold her assent. The president can withhold assent to a money bill. But once the parliament considers the same bill again, with or without the suggestions of the president, then it is binding on the president to accept that bill, sign that bill, give assent to that bill. And by looking at Article 111, do you find any mention of veto? Is absolute veto mentioned in the Constitution? Pocket veto mentions? Suspensive veto mentioned in the Constitution? No. Constitutional experts then say that this amounts to veto because there is no time period within which the president will have to act. President may give her assent in how many days, how many months, how many decades, how many centuries, not mentioned. The president may withhold her assent. The president may send the bill back for reconsideration. That's not mentioned. The time period is not mentioned. But this is what Article 111 is. And this is similar to a provision we have for the governor as well. Except that governor has one more option. Governor can reserve a bill for the consideration of the president, which we will discuss today. So if the question is asked, according to the Constitution, which of the following veto powers are available to the president? Absolute veto, suspensive veto, pocket veto, qualified veto? None of the above. You have to be absolutely clear that it is none of the above because veto is not mentioned in the Constitution at all. Okay? Great. Now, rules of procedure. I told you yesterday and I'll tell you today as well. Each house of the parliament will have the power to make rules for itself. How do we govern our house? How the bill is to be introduced? How the bill is to be passed? How questions are to be asked? Rajya Sabha will have its own rules. Lok Sabha will have its own rules. But what about rules that we have to follow for a joint sitting? What will happen in a joint sitting? Will the rules of Lok Sabha be followed or the rules of the Rajya Sabha be followed? Constitution says the president will make rules for the joint sitting. What rules will have to be followed for a joint sitting? Those rules will be made by the president. But for making these rules, the president will consult the chairman of the Council of States and the Speaker of the Lok Sabha. And it is this rule, for example, in joint sitting. I did not tell you and you did not even ask me, who will preside over the joint sitting? Constitution says at a joint sitting of the two houses, the Speaker of the House will preside over joint sitting. But sir, what if the Speaker is not present? What does Constitution say? Constitution is silent. Or Constitution does not say who else. What Constitution says? Rules will determine. These rules, which will be made by President after consultation with the Speaker and the Chairman. And according to these rules, the Speaker of the Lok Sabha will preside over joint sitting. If you are not present, then the Deputy Speaker. If you are not present, then the Deputy Chairperson of the Rajya Sabha. If you are also not present, then anyone chosen at the joint sitting. Anyone chosen at the joint sitting. That means this anyone can be from Lok Sabha and Rajya Sabha. Which means under no circumstances does the chairperson of the Rajya Sabha preside over joint sitting, because that's not mentioned in the rules, because the chairperson of the Rajya Sabha, the Vice President of India, is not a member of the Parliament, and as such, you cannot be part of the joint sitting of the two houses. Article 121 imposes a restriction on the Parliament. Don't you dare discuss the conduct of judge inside the Parliament. Yes, if you want to remove that judge, because the judge of the Supreme Court, judge of the High Court can be removed by the President after a resolution is passed by both houses of the Parliament. So Parliament will have to pass a resolution and then the President will remove that judge. But when you are passing a resolution against a judge, you have to discuss why you are removing him, why you want to remove him. You have to discuss his conduct. Only in that scenario you can discuss the conduct of that judge. Otherwise, there is a prohibition, limitation. You cannot discuss the conduct of any judge of the Supreme Court or High Court. Except when you want to remove that judge. And there is separation of powers. That courts cannot inquire into the proceedings of the Parliament. Which means if a bill is passed by the Parliament and then sent to the President for signature and then the President signs it, only after that you can challenge that bill in the courts. And I told you yesterday that an ordinary law can be challenged before the court on two grounds. If this law violates fundamental rights, or if this bill or if this law is beyond the legislative competence of the House which enacted that bill, which enacted that law. But while the judiciary will review that piece of legislation, the judiciary will not get into the procedure. Judiciary will not question why this bill was passed by voice vote and not through division of votes. Why opposition was not allowed to speak on this bill. Why there was no debate on this bill. Why this bill was passed within 5 minutes of its tabling. No. Because these are the procedures of the Parliament, there is no judicial review. Courts cannot inquire into the proceedings of the Parliament. Further, Article 123 empowers the President of India. What you can do, you can promulgate an ordinance. When either one or both houses of the Parliament are not in session. But can President promulgate an ordinance to amend the Constitution? The answer is a big no. Why? Because in ordinance, the President can promulgate an ordinance on all those items and subjects on which Parliament has the power to pass an ordinary law. Which means on any item mentioned in the union list and concurrent list, the President can promulgate an ordinance when either one or both houses of the Parliament are not in session. President cannot promulgate an ordinance under Article 123 to amend the Constitution. Also because Article 13 is categorically clear. State cannot pass any law to delete, abridge fundamental rights. And law means ordinance as well. When ordinance cannot be used to amend the fundamental rights, it cannot be used to amend the Constitution at all. And similar power is available with the governor under Article 213 of the Constitution. Let's now come to the judiciary. Article 124. Constitution says there shall be a Supreme Court of India headed by the Chief Justice of India and not more than 7 other judges. These 7 other judges are what we call the puisne judges. But can this number of judges increase from 7 to 11 to 17 to 24 to right now 33? Yes. Who has this power? This power is with the Parliament. So it is the Parliament of India which can pass a law, and through this law, it can increase the number of judges. But sir, I have a question. Making any change to the Constitution is a constitutional amendment. And constitutional amendment requires special majority. Requires the invocation of Article 368. Which means if the original Constitution says there shall be a Chief Justice of India and not more than 7 judges. If this number 7 has to become 33, for that you need to amend the Constitution, for that you need to invoke Article 368. But in this case, no. Why? Because Constitution further provides that Parliament may by law increase the number of judges, and this law shall not be deemed as an amendment to the Constitution. Which means this is to be an ordinary law passed by the simple majority. You don't need to amend the Constitution. Look at the question asked in Prelims 2014. The power to increase the number of judges in the Supreme Court of India is vested in President, Parliament, the Chief Justice of India, the Law Commission. And the answer is Parliament. Right? Very good. Now, appointment of an acting Chief Justice. If the office of the Chief Justice is vacant, or if the Chief Justice is unable to discharge his duties, maybe he is sick, or maybe he is so ill that he has lost the mental balance, then in that case, any judge of the Supreme Court can be appointed as the acting Chief Justice by the President of India. Which means one thing that you have to keep in mind is there is a concept of acting Chief Justice mentioned in the Constitution itself under Article 126. Further, appointment of ad hoc judges. Keshavananda Bharati judgment was given by 13 judges. What if we want to review that judgment? For that we have to set up a 15-judge bench or a 17-judge bench. And what if we don't have the sufficient number of judges in the Supreme Court? Then in that case, what will happen? The President of India, after consulting the Chief Justice of that High Court, will appoint an ad hoc judge. That means somebody from the High Court who is qualified to be appointed to the Supreme Court. That means you should be a High Court judge for 5 years. If you are a High Court judge for 5 years, which means you are qualified to be appointed as the judge of the Supreme Court, such a person, such a judge can be appointed as the ad hoc judge. And who can do that? The Chief Justice of India. Similarly, retired judges. If there is a lot of workload in the judiciary, can we ask the retired judge of the Supreme Court to come and present and be part of the Supreme Court proceedings? Yes. Here you will see NJAC mentioned. Here also you will see NJAC mentioned. What is this NJAC? 99th Constitutional Amendment Act was passed. The year was 2014. This constitutional body was created because we did not discuss how the judges are appointed, because that is now not being these judges are not appointed according to the constitution. These judges are appointed according to the judgment of the court, through collegium system, which is not mentioned in the constitution at all. And in 2014, the Parliament of India tried to replace collegium system with NJAC. But next year in 2015, by 4:1, Supreme Court declared NJAC as unconstitutional. This case is famously known as the fourth judge's case, or Skara versus Union of India. Supreme Court Advocates on the Records Association versus Union of India, 2015. And on the side of the petitioner was Falias Nariman, who fought heroically for judicial independence. But be that as it may, here, although the constitution was amended, but the Supreme Court declared it unconstitutional. And I told you yesterday, when the court declared something unconstitutional, that does not mean the constitution, from the constitution, those terms or those words or those articles will get deleted. They will remain same. It's just that they will not be enforced because they have been invalidated by the courts. Attendance of the retired judges at the sittings of the Supreme Court. NJAC may at any time, with the previous consent of the President, request any person who has held the office of the judge of the Supreme Court or Federal Court or the High Court that you can attend the sittings, because we are facing significant caseload. But this time, this retired judge has to give his or her consent. Without her consent, you cannot force the retired judge to be present before the court. So 3 things you have to keep in mind. Constitution provides for an acting Chief Justice when the current Chief Justice post is vacant or he is unable to discharge his duties. Who will appoint the acting Chief Justice? The President. Then Constitution further talks about for Supreme Court ad hoc judges. That means if you are a judge of the High Court, but you are qualified to be appointed as the judge of the Supreme Court, we are facing caseload right now. Please come and attend the sittings of the Supreme Court. Or attendance of the retired judges at the sittings of the Supreme Court with the consent of that retired judge. This is mentioned in the Constitution. When we compare this provision with the High Courts, there is a similar provision, which means if the Chief Justice of a High Court, this post is vacant, or the Chief Justice of this High Court is unable to discharge his duties, then in that case, the duties of the office of the Chief Justice of that High Court shall be performed by that judge as the President may appoint. But in the High Courts, We don't have ad hoc judges. We have acting judges and additional judges. Listen to me carefully. At the Supreme Court, we may have ad hoc judges. We may have retired judges attending the Supreme Court. But at the High Court level, we have acting judges and additional judges. For example, additional judge. If you're qualified to be appointed as the judge of the High Court, the president may appoint these people as additional judges, but for a maximum period of 2 years. Why? Because there is a temporary increase in the number of cases before the High Court, or the cases are pending and we need to quickly dispose of these cases. For that, we need more judges. For that, if you are somebody who is eligible to be appointed, qualified to be appointed as the judge of the High Court, the president will appoint you as the additional judge. But this is also done on the advice of the collegium. And second, when any judge of the High Court, other than the Chief Justice of India, whether because of your absence or because of the fact that you are unable to discharge your duties because of any reason, for your case, in your absence, we may appoint an acting judge. There is no such thing as ad hoc judge. There is acting judge for a High Court. Because the judge currently, either he was appointed as the acting Chief Justice, or this judge is vacant or absent. So we will have to appoint an acting judge in this case. But whether you are an additional judge or an acting judge, you cannot hold office beyond the age of 62. Long story short, at the Supreme Court, we may have acting Chief Justice of India, ad hoc judges, and retired judges. In the High Courts, we may have acting Chief Justice of that High Court, additional judges, and acting judges. There are no acting judges in the Supreme Court. And Article 129 says Supreme Court is to be the court of record, which means any judgment, any decree of the Supreme Court will have to be saved for posterity. And whenever such document is presented before any other authority, nobody can question the validity of that document. All the recordings and the proceedings of the court are recorded for posterity. And the Supreme Court has the power to punish people for contempt. That is why we say Supreme Court is the court of the record. Where does Supreme Court sit in Delhi? Can Supreme Court sit in Chennai and not Delhi? Yes. Can Supreme Court sit in Chennai as well as Delhi? Yes. Can Supreme Court sit in Bengaluru, Chennai, Delhi at the same time? Yes. Who will decide that? Chief Justice of India with the prior approval of the President. Which means Constitution under Article 130 is clear. The Supreme Court shall sit in Delhi or such other place or places as the Chief Justice of India may, with the prior approval of the President, from time to time appoint. Article 131 talks about the original jurisdiction. What is the original jurisdiction? There is something called original, and then there is something called exclusive jurisdiction. What is the difference? Can anybody tell me what's the difference? All those cases which can be directly filed in the Supreme Court, we call Supreme Court has the original jurisdiction in those cases. For example, fundamental rights violation cases. If your fundamental rights are violated, can you directly approach the Supreme Court? Yes, that means the Supreme Court has original jurisdiction on fundamental rights cases. But when we say exclusive jurisdiction, that means such cases can be heard and determined only by the Supreme Court, and no other entity has the power to determine such a case. Because can we say on fundamental rights violation cases the Supreme Court has exclusive jurisdiction? No. Because if your fundamental rights are violated, yes, you can approach the Supreme Court under Article 32. But you can also approach the High Courts under Article 226. Which means Supreme Court has original but not exclusive jurisdiction in case of fundamental rights violation case. But when it comes to federal disputes, dispute involving center versus states, or center and states on one hand and states or one state on the other hand, or if there is a dispute between Maharashtra and Karnataka, all these are called original exclusive jurisdiction of the Supreme Court. Look at the question which was asked. The power of the Supreme Court of India to decide dispute between the center and states falls under advisory, appellate, original, writ. Original jurisdiction of the court. Right or wrong? Right. Now listen to me carefully. Enlargement of the jurisdiction of the Supreme Court. Who has the power to enlarge the jurisdiction of the Supreme Court? That power is with the Parliament. So tomorrow, if the question is asked in the examination, which of the following entities have the power to enlarge the jurisdiction of the Supreme Court? That will be decided by Parliament by law. Article 139. Supreme Court has the power to issue writs, habeas corpus, mandamus, prohibition, certiorari, quo warranto. These writs can be issued by the Supreme Court for the enforcement of fundamental rights as provided under Article 32. But can Supreme Court issue these writs for the enforcement of legal rights as well? Can, yes. But who will give this power? This can be done by the Parliament. That means Parliament may by law confer power on the Supreme Court that you can issue these writs for other matters other than those mentioned in Article 32, apart from those mentioned under Article 32. Which means who has the power to expand, enlarge the jurisdiction of the Supreme Court? That power is available with the Parliament, and for that Parliament will have to pass on law. But sir, when you said, although there is no mention of the collegium system in the Constitution, but even then we follow the collegium system, how is that possible? Is that not incompatible with the provisions of Constitution? No. Why? Because Article 141 says the judgments given by the Supreme Court is the law of the land. And the law of the land as laid down by the Supreme Court is binding on all the courts within the territory of India. Article 142 talks about Supreme Court can give any order so as to give complete justice. For example, recently a Dalit boy was unable to pay 17,000 rupee IIT fee on time. When he was unable to pay, he was denied admission. Was the IIT wrong in granting him admission? No. Why? Because they followed the rules. You have to pay your fee on time. We may sympathize with you, but you will have to follow that rule. Can High Court help you? No. Can any other entity help you? No. You can go to the Supreme Court, and Supreme Court can give any order so as to give complete justice. And Supreme Court paved way for that Dalit boy to get admission in that IIT. That means even after you have failed to pay the fee on time, now for you, we can change the rule We can deviate from the rule, and now you can pay the fee and you will get admission, because we can do anything so as to give complete justice. And this is the question that was asked in the exam, Prelims 2019. With reference to the Constitution of India, prohibitions or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under Article 142. It could mean which of the following? Supreme Court is not constrained in the exercise of its powers by the laws passed by the Parliament. So even if there is a law, the court can deviate from it in order to give complete justice. For example, Supreme Court invoked Article 142 and removed the minister in Manipur, Mr. T. Shyam Kumar, who was the forests minister. Despite the fact that law is clear, the minister is appointed by the governor on the advice of the chief minister. The minister can be removed by the governor on the advice of the chief minister, because the minister holds office during the pleasure of the governor. And now the Supreme Court says, you hold office during our pleasure and we are withdrawing the pleasure, because we can do anything so as to give complete justice. And Supreme Court was not wrong there, because that individual was basically a defector. He had defected from the Congress to the BJP and even then was made a minister. Despite multiple reminders sent to the speaker that disqualify this person, take action against this person, decide upon the disqualification petition, but the speaker was hell-bent on dealing this matter. The court finally said enough is enough. A two-judge bench of the Supreme Court, led by Rohinton Fali Nariman, invoked the plenary powers of the Supreme Court under Article 142 and disqualified the minister. Which means the Supreme Court, using Article 142, can give any order so as to give complete justice. That's Article 142. Now, Article 153 talks about an advisory jurisdiction of the Supreme Court, which means President can refer any matter to the Supreme Court, asking the views of the Supreme Court on that matter, asking the advice or seeking the advice of the Supreme Court on that matter. But this is only an advice. This advice is not binding on the President. Theoretically, it's not binding on the President. If the question is asked, it's an advisory jurisdiction and the advice is not binding on the President. But technically, it becomes binding. For example, one advisory jurisdiction was on the appointment of judges. The case was of 1998, appointment of judges case, which is also known as the third judges case. The Supreme Court said that if the judge of the Supreme Court is to be appointed, for that the President shall consult the Chief Justice of India and 4 senior judges of the Supreme Court. To appoint a judge of the High Court, the President shall consult the Chief Justice of India and 2 judges. To transfer the High Court judge, you have to consult 6 judges. Although that was an advisory jurisdiction, advice is not binding on the President, but technically it becomes binding because you can't violate that. But is it binding on the Supreme Court to give this advice to the President? This is where it becomes interesting. If this matter is pre-constitutional matter, then it is binding on the Supreme Court to give the advice. Advice is still not binding, but it is binding for them that to give an advice. If it's a post-constitutional matter, it is not binding on the Supreme Court to give the advice. To give the advice. Advice is still not binding, theoretically. But whether advice should be given or not given, for that we have to decide whether this is a matter related to pre-constitution or post-constitution. And in one case, Supreme Court said, if on a pre-constitutional matter, it is binding on us to give an advice. And if in our advice we say, on this matter, we have no advice to give, even that will be deemed as an advice, because your advice is that on this matter, you have no advice to give. But whatever it is, that's Article 143, which is, by the way, not even present in the US Constitution. Advisory jurisdiction of the Supreme Court. Clear? Any questions as of now? Now let's look at a few provisions for the CAG. And CAG becomes important also because of some reports of the CAG with respect to Delhi. And those were not tabled by the Delhi government before the Delhi Legislative Assembly. And there's a lot of controversy on that. And now the new government in Delhi has said that we will forthwith table those reports before the Delhi Legislative Assembly. So CAG office becomes important for the upcoming exams. There shall be CAG, Comptroller and the Auditor General of India, which means it's a constitutional post, who will be appointed by President by warrant under his hand and seal. But what do we mean by warrant under his hand and seal? That means this power of appointment, President cannot delegate to someone else. For example, the President appoints the Chief Minister of Delhi. But you saw it was the Delhi Lieutenant Governor who administered oath of office and secrecy to the new Chief Minister. Which means the Chief Minister of Delhi is appointed by the President, but not under warrant of his hand and seal. You can delegate this responsibility to someone else. But CAG is appointed by the President by warrant under his hand and seal, which means he cannot delegate this appointment to someone else. And you have a protection that you can be removed in the same manner and on the like grounds as the Judge of the Supreme Court. And Judge of the Supreme Court is removed on what grounds? Crude misbehavior, incapacity. And what is the manner? Manner, I've told you that the Judge of the Supreme Court or High Court can be removed only after a resolution is passed by both houses of the Parliament by special majority, and then this resolution is forwarded to the President and the President removes that judge. But the President can remove a judge and the grounds of removal are misbehavior or incapacity. But for that, the process, detailed process is mentioned under the Judges Inquiry Act of 1968. So the CAG shall be appointed by the President by warrant under his hand and seal, and shall be removed by the President in the same manner and on the like grounds as the Judge of the Supreme Court is removed. And every person who is appointed as the CAG, oath is administered by the President. And before you assume office, you have to subscribe to this oath, and that oath is mentioned in the third schedule of the Constitution. And this salary or any other condition of CAG is determined by Parliament. Who decides the remuneration of the Attorney General for India? President. Who decides the salary of the CAG? Parliament. Provided that the salary of the CAG or his retirement age or pension, it cannot be varied to his disadvantage after the appointment. And this provision is meant to ensure independence of the CAG. Once appointed, your salary or other conditions of service shall not be varied to your disadvantage. Another important thing for CAG is that you are ineligible for further office, either under the Government of India or Government of any state. For example, once you're appointed as the CAG, your term is, let's say, for 6 years or till the age of 65, whichever is earlier. Once you cease to remain the CAG, then you are ineligible for further employment, either under the Government of India or Government of the state. But can the CAG be appointed as a governor or can be elected as the president? Yes. Because governor is not the employment. You cannot be further employed by the Government of India or Government of state. That's the limitation. And all your expenses, all your salary, not just of yours, but your entire office, these expenses are charged on the Consolidated Fund of India. When these are charged on the Consolidated Fund of India, that means Lok Sabha can discuss, Parliament can discuss such expenditure. But such expenditure shall not be votable. Once your salary is decided, every year you don't have to pass an appropriation bill to get salary for the CAG. It is charged on the Consolidated Fund of India. Further, reports, the audit reports prepared by the CAG. Because once these CAG reports are prepared, these CAG reports are given to the President if it is related to the Union, are given to the Governor if it is related to a state, and then it shall be the responsibility of the President and the responsibility of the Governor to lay these CAG reports before the Parliament and the state legislature. And after that, these reports are examined by the Public Accounts Committee. And you should know that the chairman of this Public Accounts Committee is invariably from the opposition. And then we also say that CAG is the friend, philosopher, and guide of the Public Accounts Committee. Right or wrong? Right. Then part 6 deals with the states. So part 1, Union and its territory. Part 2, citizenship. Part 3, fundamental rights. Part 4, directive principles of the state policy. Part 4, capital A, fundamental duties. Part 5, Union, which includes Union Executive, Union Legislature, which includes Supreme Court as well, CAG as well, Attorney General as well. But then we have part 6 of the Constitution, which deals with states. Here also, let me tell you, and I'll reiterate, if you have understood Union Legislature, Union Executive, you don't have to discuss state machinery separately. With some variations, with some exceptions, and those exceptions we are going to cover now. For example, Article 153 says governors of states. There shall be a governor for each state. But can the same governor be appointed to more than one state? Yes. But this originally was not part of the Constitution. This was added to the Constitution by the 7th Constitutional Amendment Act 1956. So there shall be a governor for each state, but Constitution does not prohibit the same person from being appointed as the governor to more than one state as well, which originally was not part of the Constitution, but it was added to the Constitution by the 7th Constitutional Amendment Act 1956. But what is the term of the office of the governor? The governor shall hold office during the pleasure of the president, which means he or she lacks security of tenure. Although the tenure is mentioned in the Constitution, normally 5 years, but this is subject to doctrine of pleasure, which means although you are a governor appointed by the president for a period of 5 years, but at any point in time, the president may withdraw pleasure and remove you or transfer you, which means it is not the personal pleasure of the president, because Supreme Court once said that there was a petition before the court, Shamsher Singh versus State of Punjab, that Constitution talks about a term called satisfaction of the president. If the president is satisfied, the court said it is not the personal satisfaction of the president, it's the satisfaction of the Council of Ministers headed by the Prime Minister, because we follow parliamentary system. So although we say that the governor shall hold office during the pleasure of the president, in reality it means pleasure of the Prime Minister and his Council of Ministers. Which means although the term 5 years, listen to me carefully, important for your exam, the tenure of 5 years is mentioned in the Constitution for the governor, but that is subject to the pleasure of the president. And at any point in time, the governor may, by writing a letter of resignation, resign from his office by sending this letter of resignation to the President of India. 2013, question asked in the prelims examination. Which of the following statements is or are correct? Take a look at the screen and let me know what is the right answer. In India, the same person cannot be appointed as the governor for 2 or more states at the same time. Question is asking which of the statements are correct. You know this is not correct because 7th Constitutional Amendment Act 1956 provides it. The judges of the High Court of States in India are appointed by the governor of that state, just as the judges of the Supreme Court are appointed by the president. The judges of the Supreme Court and the High Court are appointed by the president. In case of a union territory having a legislative setup, the chief minister is appointed by the lieutenant governor on the basis of majority support. Appointed by the president in case of a union territory. No procedure has been laid down in the Constitution of India for the removal of the governor from his post. Clear, it's not mentioned. The only thing which is mentioned is you hold office during the pleasure of the president. Is there an impeachment process followed? No. But what is the qualification for someone in order to be appointed as the governor of a state? Constitution only says that there are 2 qualifications. You have to be the citizen of India and you must have completed 35 years of age, full stop. Sir, we have read that the qualification is that the governor should be a non-resident, which means if a governor to Karnataka is to be appointed, he should not be from Karnataka. Or while appointing the governor to a state, the chief minister shall be consulted. These are only conventions, unwritten rules. But Constitution is clear, there are only 2 qualifications. One, you have to be the citizen of India and you must have completed 35 years of age. Then you are eligible to be appointed as the governor of a state. Article 158 says something else. And listen to me carefully. The governor shall not be a member of either house of the parliament. The governor cannot be the member of either house of the state legislature. But what if an MP or an MLA is appointed as the governor, then the moment you assume office, it shall be deemed that you have vacated your seat. Which means today, if I am an MLA or I am an MP and I am appointed as the president, appointed by the president as the governor of Karnataka, then the moment I am assuming the office of the governor of Karnataka, it shall be assumed that I have vacated my seat in that house. The governor shall not hold any other office of profit mentioned in the constitution. When the same person is appointed as the governor of two or more states, now there can be a tussle between the two states. Who will pay salary to the governor? The entire salary will be paid by us, or entire salary will be paid by the other state. Then it shall be allocated among the states in such proportion as the president may by order determine. Whether 50% we have to pay, 20% for 50% you have to pay, or it has to be allocated in a different way. That president will determine. This can be a very important fact for your prelims. And the allowances, the salary of the governor shall not be diminished, vary to his disadvantage during his appointment. This is also to prevent independence of the office of the governor. Further, Article 163 and link it to Article 74 of the Constitution. Article 74 says, there shall be Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall act on that advice, provided the President may ask for reconsideration of that advice. But once the same advice is given, it's binding on the President to accept that advice. But when it comes to the office of governor, Constitution says there shall be Council of Ministers with the Chief Minister at the head to aid and advise the governor, who shall act on that advice, except in those instances where the governor is bound to act in his discretion. That means whatever advice is tendered by Council of Ministers and the Chief Minister to me, to governor, it's binding on me, except when I have to act in my discretion, which means except when I'm not bound by your aid and advice. But Constitution further says, if there is a dispute as to what constitutes the discretionary power of the governor, the word of the governor shall be final. Which means the problem here is that what are these discretionary powers? These are not codified in the Constitution. When these are not codified in the Constitution, that means this is the potential clash between the Chief Minister and the governor. And we witness such clashes, particularly when the governor is appointed by the center to a state which is ruled by the opposition. For example, Mr. Bhagwant Mann is the Chief Minister of Punjab, and we have a governor appointed by the central government to Punjab. And the Punjab government had sent I think 200 odd teachers to Singapore to see how the education system is functioning and working in Singapore. The governor interfered, and the governor asked Bhagwant Mann in a letter that please tell me, on what basis did you choose these 200 odd teachers? What is their qualification that you chose them and not others? Bhagwant Mann replied in his letter to the governor, what is your qualification? On what basis you were appointed as the governor of a state? And the governor got offended. And later, when the governor was advised, please summon the legislature, the governor said, I'm not going to do that because this is my discretion. I'm not bound by your aid and advice because I can act in my discretion. And if tomorrow there is a dispute as to what constitutes my discretionary power, the word of the governor shall be final. Ultimately, matter went to the court, and the Supreme Court castigated both the Chief Minister and the governor and told the governor that this is not your discretionary power. But be that as it may, that means what constitutes these discretionary powers, we will have to, if at all there is a dispute, and there are many, we ideally have to go to the courts. And there are lots and lots of cases already pending before the court, particularly when it comes to states such as Tamil Nadu, states such as Kerala, Telangana, Karnataka as well, Punjab, West Bengal, not to forget. For example, there was another instance where governor's address, similar to president's address, there is a governor's address as well. I told you that the president's address, the text is provided by the cabinet. Similarly, for the governor's address, the text is provided by the cabinet. The cabinet of Tamil Nadu government provided the text of this governor's address to Governor Ravi. And there were references to Periyar, to Karunanidhi, to B.R. Ambedkar. And the governor skipped those references, those portions which refer to the Periyar, to Karunanidhi, to Dr. Ambedkar. And the chief minister became angry, and the chief minister got up in the legislative assembly and said that we will adopt the speech which we have prepared, not the speech which the governor has read. Governor could not understand because the chief minister was speaking in Tamil. But when somebody told governor that this is what Stalin has said, the governor, in a tearing hurry, he left the premises of the legislative assembly. But we don't have to get into that. That is relevant for the mains examination. We are here focusing on the prelims examination. So where were we? Whatever advice is given by the Council of Ministers, headed by the Chief Minister, to the governor, that's binding on the governor, except in cases where the governor is bound to act in his discretion. But what are these discretionary powers? These are not codified by the Constitution. But Constitution does say, if at all there is a dispute as to what constitutes the discretionary power of the governor, the word of the governor shall be final. And this advice, and what advice was tendered by the Council of Ministers to the governor, shall not be inquired into any court of law. And this is similar to Article 74, Clause 2 of the Constitution. Right or wrong? Right. Let's look at other provisions as to ministers. The chief minister shall be appointed by the governor. And again, this is what we call the situational discretion. And this is where I'll tell you some interesting story, just so that we are breaking this monotony. Otherwise, I have bombarded you with lots and lots of facts, and maybe some of you would be bored as well. Now, as an aside, let me tell you a story. Constitution says the chief minister shall be appointed by the governor. But who that chief minister is going to be, Constitution is not clear on that. Normally, if there is a political party which has won the election, the leader of that party is appointed as the chief minister by the governor, because in that case, the governor does not have a discretion. But this discretion comes up when there is a hung assembly, when no political party has the majority on its own. In that case, the chief minister is appointed by the governor, and the governor has a situational discretion in this case. For example, in Karnataka and Goa, elections were held in 2017. And in Karnataka, no political party got the majority. In Goa, no political party got the majority. But in Karnataka, BJP emerged as the single largest party. In Goa, Congress emerged as the single largest party. But in Karnataka, Congress and the JDS, they decided to come together to form the government. In Goa, others, BJP and smaller parties, they decided to come together to form the government. Ruling party is that of the center, in the center by the BJP. So BJP is appointing governors to Karnataka as well as Goa. When JDS and Congress approached the governor, Mr. Vala, that we have the numbers, we want to form the government. Governor said, no, I am not going to invite you. I'm not going to invite Kumaraswamy, who was chosen by Congress and JDS. I am going to invite Yediyurappa. Why? Because Yediyurappa is the leader of the single largest party. Because in case there is a hung assembly, I normally have to invite the leader of the single largest party to form the government. So I'm appointing Yediyurappa as the chief minister. In Goa, Congress tried to apply the same. Governor Miss Sinha, we are the leader of the single largest party. Please invite us to form the government. Governor said, no, I won't invite you. I invite BJP and others. Why? Because it's not binding on me to invite the leader of the single largest party, because I don't care about it. What I care about is the stability of the government. And I think you cannot provide stability, provide a stable government. I think the BJP and smaller parties together can provide a stable government. So in choosing a chief minister, the governors have been alleged to have misused their discretionary powers. But there is an element of discretion, because Constitution only says the chief minister shall be appointed by the governor. Right? And then other ministers shall be appointed by the governor on the advice of the chief minister. So in appointing a chief minister, the governor may have a discretion. But in appointing other ministers, there is no discretion on part of the governor. The governor has to appoint only those ministers who are recommended by the chief minister. But Constitution says further, there are states such as Chhattisgarh, Jharkhand, Madhya Pradesh and Odisha. In these states, necessarily there has to be a minister in charge of tribal welfare, who may also be in charge of the welfare of the scheduled caste and backward classes, or you may assign any other work. But there has to be a minister in charge of the tribal welfare in these states such as Chhattisgarh, Jharkhand, Madhya Pradesh and Odisha. The total number of ministers, including the chief minister, shall not be more than 15% of the Legislative Assembly. And again, this is something which was not originally part of the Constitution. It was added to the Constitution by the 91st Constitutional Amendment Act 2003. But if the maximum number is not more than 15%, what is the minimum? Minimum is 12. You can't have less than 12 ministers, neither at the central level nor in the state level. Sir, I have a question. What? In Delhi, we have chief minister and 6 ministers. Why don't we have 12 ministers in Delhi? For Delhi, there is a separate provision under Article 239, capital AA, double capital A, and that we will discuss today. Abolition or the creation of legislative councils. At the central level, we have the bicameral legislature, which means we have Lok Sabha and the Rajya Sabha. There are some states where we have 2 houses, bicameral legislature, where we have a legislative council and we have a legislative assembly. Which are these states? States such as Andhra, Telangana, Maharashtra, Bihar, Uttar Pradesh, Karnataka. These are the 6 states where we have bicameral legislature. But can we abolish legislative council in Andhra Pradesh? Or can we establish legislative council in, let's say, Tamil Nadu? Yes, that can be done. But according to Article 169, who has that power? That power to establish a legislative council in a state where it is not present, or to abolish a legislative council in a state where it is present. This power is with the Parliament. But Parliament cannot act on her own. For that, Parliament will have to wait for the resolution to be passed by the Legislative Assembly. If the Legislative Assembly of Andhra Pradesh passes a resolution, by what type of majority? By flavor 1 of special majority, not less than 2/3 of the members present and voting. If Andhra Pradesh Legislative Assembly passes a resolution by the majority of not less than 2/3 of the members present and voting, then Parliament can use that resolution and abolish Legislative Council for Andhra. If Tamil Nadu passes a resolution by not less than 2/3 of the members present and voting, then this resolution can be used by the Parliament to enact a law and establish Legislative Council for Tamil Nadu. And when Parliament will pass such a law, this law shall not be deemed as an amendment to the Constitution. Which means for that you don't have to use Article 368. This law can be an ordinary law. And you know ordinary laws are passed by simple majority. Resolution by the Legislative Assembly will be by special majority, but the Parliament will pass such a law by simple majority. Then Article 182, listen to me carefully. We have the chairman of the Rajya Sabha. Is the chairman of Rajya Sabha member of the Rajya Sabha? No. Vice President of India is the ex officio chairperson of the Rajya Sabha. You are not the member of the Rajya Sabha. But what about the chairman and the deputy chairman of Legislative Council? Both these individuals are elected. Just like we have for Lok Sabha, that the House of the People shall, as soon as may be, choose two of its members. One is the Speaker, the other is the Deputy Speaker. Similarly, for Legislative Council also, the Chairman and the Deputy Chairman, they are chosen, they are elected. And in fact, this was the question asked in one of the prelims examination, that while the Chairman of the Legislative Council is nominated, the Deputy Chairman is elected. Both the chairman as well as deputy chairman, they are elected, they are chosen by the Legislative Council, according to Article 182 of the Constitution. Restriction on powers of Legislative Council as to bills other than money bills. What are these restrictions? Listen to me carefully. In those states where we have Legislative Council, we have Legislative Assembly as well, bicameral legislature. If a bill has been passed by Legislative Council, it has been passed by Legislative Assembly as well, there is no dispute, there is no confusion, there is no problem whatsoever. But if the Legislative Assembly passes a bill and if the Legislative Council passes a bill and the Legislative Assembly rejects that bill, the bill is dead. Which means there is no question of joint sitting of the two houses of the state legislature. And that is why we say Legislative Council is considered to be the secondary chamber of legislature, of state legislature. Secondary in a sense, inferior. Rajya Sabha is not considered to be the secondary chamber. Rajya Sabha is considered to be the second chamber of Indian Parliament. But let's reverse the situation. Let's now say that we have Legislative Assembly and here we have Legislative Council. If Legislative Assembly passes a bill, Legislative Council passes a bill, what will happen to this bill? The bill is passed. No doubt, no dispute, no confusion. Legislative Assembly passes a bill, Legislative Council can reject a bill. Legislative Assembly passes a bill, Legislative Council may not act on this bill. Legislative Assembly passes a bill, Legislative Council amends this bill. These are the options available with the Legislative Council. What will happen in this situation now? In this situation now, when the bill is rejected by Legislative Council, it will go back to Legislative Assembly. If Legislative Assembly passes this bill again and Legislative Council rejects this bill again, even then the bill is passed. That means Legislative Council has an inferior role. If Legislative Council may not act on this bill, then we will wait for 3 months. After 3 months, this bill will go back to Legislative Assembly. Legislative Assembly says, how dare you not act on our bill for 3 months? We will pass our bill again. Legislative Council says, how dare you pass the same bill again? I will again not act on this bill. But this time we will wait for 1 more month. After the expiry of 1 month, when it is retransmitted again, the bill is passed. In the same manner, it was passed by Legislative Assembly, which means Legislative Council is inferior. Legislative Assembly passes a bill, Legislative Council amends the bill. This bill will go back to Legislative Assembly. If Legislative Assembly accepts these amendments, the bill is passed. If the Legislative Assembly does not accept these amendments, then this bill goes back to Legislative Council. Now this time, if Legislative Council amends it again, even then the bill is passed in the same shape, in the same form as it was passed by the Legislative Assembly, which means, long story short, Legislative Council has an inferior role. But this cannot happen in case of a money bill, because money bill, once it is transmitted to Legislative Council cannot reject it, cannot amend it, and has to pass within 14 days. If it doesn't, then it shall be deemed to have been passed. And what I presented you here, that is what is mentioned in this text. And I just simplified it for you, which is, if after a bill has been passed for the second time by the Legislative Assembly, then transmitted to the Legislative Council, if the bill is again rejected by the Council, or more than 1 month elapses, or the Council amends it again, even then the bill is deemed to have been passed. Right or wrong? Right. Article 200 gives the power to the governor regarding the assent to bills. What are the bills? Bills are the proposals passed by both houses of the parliament. Once this bill is passed by both houses of the parliament, it is sent to the president. Similarly, a bill passed by the legislature of a state, whether it is Legislative Assembly and Legislative Council, both in bicameral legislatures or in unicameral legislatures only by the Legislative Assembly. When the bill is passed by the Legislative Assembly, it is sent to the governor. What are the options available with the governor? Under Article 200, the governor may give assent, the governor may withhold assent, and once you withhold, you will have to immediately send the bill back for reconsideration. But then there is also another option available with the governor, that you can reserve a bill for the consideration of the president. This topic can be very important for the upcoming mains exam, because the Supreme Court has said that it can't be a mechanical exercise, where mechanically you are getting a bill passed by the Legislative Assembly and you reserve it mechanically for the president without applying your logic. But be that as it may, for the prelims, what you need to understand is that now there is another option for the governor. You can reserve a bill for the consideration of the president. Can the governor reserve even a money bill for the consideration of the president? Yes. And this is discretionary power of the governor. Reservation of bills for the consideration of the president or assent to bills. This is considered to be the discretionary power of the governor. But there is one aspect. In one situation, it is not the discretion of the governor, it is mandatory for the governor. What is mandatory for the governor? If the state legislature passes a bill which threatens the power of the High Court, then it is not the discretion of the governor, it is mandatory for the governor to reserve that bill for the consideration of the president. For such bill, it is mandatory. For others, it is discretion. This you might have heard, but what you may not have heard is, what happens when the governor sends the bill for the consideration of the, reserves a bill for the consideration of the president, and then president sends this bill back to the state legislature that reconsidered this bill. Within 6 months, the legislature has to reconsider that bill. That's a limit. And that limit is mentioned in the Constitution. And that limit can be asked in your prelims exam. So what are you trying to say? When a bill is reserved by the governor for the consideration of the president shall declare that either I am assenting to this bill or I am not assenting, I am withholding. Which means even if a money bill is reserved for the president by the governor, the president may declare either I am signing this money bill or I am withholding my assent. But if it is other than money bill, the president may direct the governor that you reserve this bill for me. Now I am telling you, you send this bill back to the legislature, ask the legislature to reconsider this bill. And once this bill has been sent back to the legislature for reconsideration, the legislature will have to reconsider it within a period of 6 months from the receipt of such message. This is mentioned under Article 201 of the Constitution. Clear? Any questions as of now? Okay. Article 214 talks about high courts for every state. That means there shall be a high court for each state. But is it mandatory that there has to be one high court for one state? That means one high court for one state? Or can there be a joint high courts as well? Every state has to come under the jurisdiction of a high court. But that does not mean for every state there has to be its own high court. Which means there is a provision for joint high courts as well. And that is why for 28 states and 8 union territories in India, we have 25 high courts in India. And this high court, just like Supreme Court, also act as the court of record, which means its verdicts, its decrees, its judgments are saved for posterity, are recorded. And High Court has the power to punish for its contempt. Can the district court punish somebody for its contempt? No. Does that mean you can commit contempt of the district court? No. Because if you commit contempt of the district court, High Court of that state will punish you, but not the district court. That means High Court of that state will punish you on behalf of the district court for committing contempt of the district court. But district court itself cannot punish you, which means district court is not a court of record. Which means in India, the Supreme Court and High Courts act as the court of record. And Constitution further says that every High Court will consist of Chief Justice of that High Court and such other judges as the President may from time to time deem it necessary to appoint. Now compare this Article 216 with Article 124. Article 124 said there shall be a Chief Justice of India, there shall be a Supreme Court of India headed by the Chief Justice and not more than 7 judges. And who has the power to increase the number of judges? Parliament. But who has the power to decide the composition of a high court? That power is with the president, because every high court shall consist of a Chief Justice and as many judges as may be necessary to appoint by the President of India. Restriction on practice after being a permanent judge. Now, if you have been a permanent judge of the Gujarat High Court, after your retirement, can you practice as a lawyer in the Gujarat High Court? No. Can you practice in the Bombay High Court? Yes. Can you practice in the Supreme Court? Yes. Which means no person who, after the commencement of this constitution, has held office as a permanent judge of a high court shall plead or act in any court or before any authority in India except the Supreme Court and other high courts. Other high courts means the high courts where you have not served. Which means if you have served in the Calcutta High Court and the Madras High Court and the Bombay High Court and the Punjab and Haryana High Court, after your retirement, you cannot work in these courts. You cannot be a lawyer, practicing lawyer in these courts. You can only practice in the Supreme Court and other courts where you have not served. That's Article 220. High courts and their extension to union territories. For example, there are only 2 UTs which have their own high courts. Which are these 2 UTs which have their own high courts? One is Delhi, the other is Jammu and Kashmir. All other union territories come under the jurisdiction of the neighboring states' high court. For example, Daman and Diu and Dadra and Nagar Haveli comes under the Bombay High Court's jurisdiction. Puducherry comes under the Madras High Court's jurisdiction. Lakshadweep comes under the Kerala High Court's jurisdiction. Right? Ladakh comes under the jurisdiction of Jammu and Kashmir High Court. Chandigarh comes under the jurisdiction of the Punjab and Haryana High Court. Andaman and Nicobar Islands comes under the jurisdiction of the Calcutta High Court. Which means who has that power to extend the jurisdiction of a high court to a union territory, or to exclude that union territory jurisdiction from a particular high court? This power is also given to the Parliament, not President, not Chief Justice, not anyone else. This power is with the Parliament. This fact is very important for your prelims. So, part 1, Union and its territory. Part 2, citizenship. Part 3, fundamental rights. Part 4, DPSPs. Part 4, capital A, fundamental duties. Part 5, union. Part 6, states. Part 7 used to be there, but this part 7 was omitted. When the reorganization of the country took place, based on the recommendations of the first States Reorganization Commission, or Fazal Ali Commission as it is called, headed by Fazal Ali, H.N. Kunzru, K.M. Panikar. States Reorganization Act was passed in 1956. And at that time, using 7th Constitutional Amendment Act, this part 7 was omitted, deleted. Why? Because this part 7 dealt with those states which are under part B of the first schedule. Part B of the first schedule, because at that time, at the time of the commencement of the Constitution, we had part A, part B, part C, part D territories. Part A were those territories which were under the control of the Governor General previously. For example, Bombay, Madras, Calcutta. Part B were those which were previously princely states. For example, Hyderabad. For example, Jammu and Kashmir. And that is why once that reorganization took place, when the country was reorganized into 14 states and 6 union territories, Part 7 of the Constitution was repealed, omitted. Now let's come to Part 8 of the Constitution, Union Territories. Now listen to me carefully. Article 239, it gives power to the Parliament. That dear Parliament, what you can do, you can enact a law. And then this union territory shall be administered by the President. But the President will administer these union territories through an administrator with such designation as he may specify. Which means for union territories, normally we have an administrator. But what is the designation given to that administrator? Can be a chief commissioner, can be a lieutenant governor. The Constitution says every union territory shall be administered by the President through an administrator who can be suitably named. But then Constitution further says that for some union territories, Parliament may through law provide something else, which is Article 239 capital A. Creation of local legislatures or council of ministers or both for certain union territories. And this certain union territory is used for Puducherry. Sir, what are you trying to say? Listen to me carefully. Part 8 of the Constitution deals with union territories. Constitution says under Article 239 that every union territory is administered by the President, because union territories are directly controlled by the center, directly governed by the center. And since the executive head of the center is the President, executive head of the union territory is the President. Because these union territories, they do not share federal relationship with the center. And every union territory shall be administered by the President. But for that, President may appoint an administrator as well. And the administrator can be given any suitable designation, which can be a lieutenant governor, which can be an administrator, which can be a chief commissioner. But for other union territories, some union territories, Parliament may by law provide for a different structure. For example, 239 capital A in 1962 said for Puducherry, for the union territory of Puducherry, Parliament may by law create a body called Legislative Assembly. And now listen to me carefully. This Legislative Assembly can be elected or partly nominated, partly elected. So body can be created, a group of people can be created, whether these are all elected people or some are elected, some are nominated. Parliament may by law also provide for Council of Ministers. So either Council of Ministers or a legislature or both. For whom? For Puducherry. By whom? By the Parliament. Now listen to me carefully. There is a union territory, for example, Ladakh. Or should we say, let's take Ladakh. The neighboring state is Himachal Pradesh. Can the governor of Himachal Pradesh be appointed as the lieutenant governor or the administrator of Ladakh? Yes. And when that lieutenant governor has to administer Ladakh, does that lieutenant governor has to act on the aid and advice of the Haryana, Himachal Chief Minister and Council of Ministers? No. The President may appoint the governor of a state as the administrator of an adjoining union territory. And where a governor is so appointed, he shall exercise his functions independently of his Council of Ministers. And Puducherry was the first union territory to be provided with a Legislative Assembly and Council of Ministers. And then Article 239 AA was inserted by the 69th Constitutional Amendment Act 1991. And the Parliament said, Constitution said, now this Delhi will be renamed as the NCT of Delhi, National Capital Territory of Delhi. And for this Delhi, we will have a legislative assembly with 70 seats. For this Delhi, we will have a chief minister and council of ministers as well. For this Delhi, the strength of the chief minister and council of ministers shall not be more than 10% of the legislative assembly, which means maximum you can have 7 ministers, including the chief minister. And when this legislative assembly is created for Delhi, this legislative assembly will not have the power to make a law on law and order, land, and police. And this chief minister and the ministers will be appointed by President. So Article 239 deals with union territories. Article 239A deals with Puducherry. Article 239AA deals with NCT of Delhi. And when the Jammu and Kashmir Reorganization Act was passed in 2019, that law says whatever is true for Puducherry, that is true for J&K as well. That means the provisions of Article 239 capital A apply to Jammu and Kashmir as well. Because 239A talks about creation of local legislatures or council of ministers or both for certain union territories. Now, the last thing that you need to understand here is that the president has the power. What president has the power? That it can make regulations for certain union territories. For what? For peace, for progress, for good governance. But for which union territories can the president make regulations for good governance, peace, and progress? That can be important for your exam. And which are these union territories? Andaman and Nicobar, Lakshadweep, Dadra and Nagar Haveli, and Daman and Diu. Because previously these were 2 separate UTs. Now this is 1 UT. As well as Puducherry. Not for others, only for these 4. But for Puducherry, the president can make regulations for good governance, peace and progress only when the Legislative Assembly of Puducherry is suspended or dissolved. And when the Legislative Assembly of Puducherry is alive, during that time, the president cannot make regulations for peace, progress and good governance for Puducherry. For others, they don't have legislative assembly, so the president can make regulations for peace, progress, good governance for these UTs at any time. But for Puducherry, only when the legislative assembly is suspended or dissolved. I think that should be it for today. It's already more than 3 hours, 15 minutes. We will meet again. I will notify you the day when we will meet again. And in that third and the last class, we will discuss panchayats, we will discuss municipalities, we shall discuss cooperative societies, we will discuss center-state relations, we will discuss emergency provisions, we will discuss special provisions for certain states, we will discuss schedules once and for all. And that class also is going to be for 2 to 3 hour duration. So in total, in 9 to 10 hours, we will be covering the entire bare act of the Constitution. And if you have enjoyed the session, got benefited from the session, please let me know in the comment section. Once the session will be over, once we will end the live stream, Please drop in your comments as well after the live stream ends. Let me know in the comment section, and don't forget to like this video. I'll see you when I see you. Till then, all the best. Bye-bye. Good night.